and it is 9:03. I am Mark Salone. I want to thank you all for attending or participating. And first, before I go any further, let me publicly acknowledge the hard work of the staff. As a taxpayer, I can surely say that we have gotten our money's worth. The work that they've put in is unbelievable. And you all would be proud if you knew about their efforts. Having said that, Ms. Saltmarsh, would you kindly conduct a roll call?
All right, Chairman Salone is present. Cheryl Ingram. Please take yourselves off mute so I can hear you, since I'm not looking at my screen as I do this. Judge Ingram, are you with us?
Yes. Yes.
Steve, thank you, I got you. Steve Sawyer. Kelly Cassidy. I see you, Kelly, but I'm not hearing you.
Sorry, I'm here. I was having some trouble with my audio. Can you hear me now?
Yes. Senator Peters.
I'm here.
Okay. Senator Bailey. Bob Berlin.
I'm here.
Sharon Mitchell or Jim Jacobs.
I'm here, appearing for Mr. Mitchell.
Okay. Lisa Daniels.
I'm here.
Latoya Hughes.
Present.
Joby Cates.
Good morning.
And I received an email that Orlando Mayorgas is the designee for Jacob Delaney. Orlando, are you with us?
Yes, I am present.
Shobha Mahadev.
I'm here.
Scott Main.
Here.
Ari Jones. Ari, I thought I saw you, but I'm not hearing you, so unmute
Yes,
yourself.
can you hear me now?
Yep, there we
Okay.
go.
Present.
Representative Spain. Mitchell Davis.
Here.
And Bob Berlin. Oh, I already got Bob Berlin. I think that is everybody. And we have quorum, Chairman Swin, so we can go ahead and proceed.
Very well. Everyone should have received a copy of our July 15th meeting minutes. Are there any additions or corrections to be made? Hearing none, I'll entertain a motion to accept the minutes of our July 15th meeting.
Actually,
I do have something. I raised my hand. I don't know if you can see it.
I just saw
Oh,
you.
yes, yes, I'm sorry.
Could you spell my name correctly? In the minutes?
Oh, did we misspell your name?
Of course, everybody does.
Sorry. We will
Everybody
correct
does.
that.
Everybody does.
We will correct that. So sorry about that.
No problem. Thank you.
And with that correction, is there a motion to receive, to accept the corrected minutes of July 15th?
So moved.
Is there a second, please?
Second.
Okay, it's moved and second. The motion carries. Ms. Lloyd?
Yes, Chairman Sung. Before we jump into the agenda, I would like to ask John to remind everybody of the rules of the road on Zoom and maybe say a sentence or two about who's handling what this morning.
Yes. So welcome to the meeting. So rules of the road for Zoom. We will have a chat feature in the chat box called Chatbot, I believe, that will be monitoring the queue for speaking. We will have people monitoring hand raises and we will list people in the chat bot, in the chat queue, as we see your hands raised. If there are any technical difficulties or anything, send me an email at john.specker@illinois.gov. We ask that when you do speak, when it's your turn to speak, that you activate your camera and are on camera when you are speaking. We do ask any members of the public who are not members of the task force to either use the call-in or remain off video as well. If you are skipped over in our chat queue or you do not have your turn to speak, you can reach out to Ryan Kennedy directly through the chat window or Mark Powers. And if you would like to make a comment in the chat or an email, you can email mark.powers@illinois.gov or just write your comment in the chat to everyone. When you are speaking, there will be a 5-minute limit to comments. So we ask that you please keep your comments to 5 minutes or less. Mark Powers will be warning you when you are approaching 1 minute left in your comment period. After your comment period is up, we will then mute you. And if you would like to continue to speak again, you will go back to the end of the queue and we will go through and get around to your next point when we have the other people speaking. For the public comment period at the end, I believe we will allow 3 minutes per public comment, and we will have a 1-minute warning as well. We ask that when you're not speaking, you're muted and you're not speaking, and then your names are spelled correctly and kind of clarified about who you are and what organization you represent, so everyone has an understanding when you are speaking of who is speaking at the time. Anything else that you would like me to touch on, Susan?
No, I think that's good. Thanks very much.
Thank
Good
you.
morning, everyone. We have a really busy agenda this morning. We have multiple goals.
Susan, wait,
The first
we
one-
need to do the roll call for the minutes.
My apologies.
Sorry.
No, I apologize.
That's the rule of the road for voting on a virtual meeting. So Chairman Salone,
Yay.
Cheryl Ingram. Okay. Kelly Cassidy,
Yes.
Senator Peters,
Yes.
Chief Davis,
Yes.
Ari Jones,
Yes.
Scott Main,
Yes.
Shobha Mahadev,
Yes.
Orlando Mayorgas,
Yes.
Joby Cates,
Yes.
Latoya Hughes. Okay, Latoya, I'm not hearing you, but we'll come back to you. Lisa Daniels.
Yes.
And I saw Sharon for the record. Sharon Mitchell has joined us. Sharon,
Yes. Yes.
Bob Berlin,
Yes.
Ryan Spain. I don't think I saw him join us. Okay, and just to cover my bases, Senator Bailey and Steve Sawyer.
Kathy, Jen Passwater's here. I don't know if she's voting for Spain or not.
She is not his designee, but thanks, Mike. She is his historian, so she can't vote. Okay.
Kathy,
Uh,
Kathy, did I miss my name? I'm sorry.
Oh, there you go. I'm sorry. I did call you, but then I said I would go back to you. So Latoya Hughes.
Yes, thank you.
All right. We have unanimous approval, Mr. Chairman.
Thank you. And now the motion passed. Okay. Back to you, Ms. Lloyd.
The first order of business this morning is going, once we get through these preliminary remarks, is going to be taking up the remaining principles. In your packet, you received the list of principles that will be considered today, as well as those that have been approved at the last meeting. As you might recall, the principles are really guideposts that will help shape the recommendations going forward. We have Abigail on the line who will, as in the last meeting, do live correction of the language as we have the conversation. Following that, we'll have a conversation about retroactivity, eligibility, and a number of elements of process for resentencing. The Judge Sloan, will make a few comments about retroactivity, followed by Kathy, who's going to remind us of the background, the rationale and factual basis for this resentencing effort. And then we'll go through some recommendations, recommended or draft proposals. Having said that, Judge Sloan, you want to take it away?
Thank you. As you will recall, in our last meeting, we did not resolve principles 7, 10, 11, and 12. And so now I propose to proceed to address the revised principle number 7. And this also was included in the email to each of you. That principle reads as follows: victims shall be notified of the resentencing process proceeding. Authorize the judicial decision maker to consider any victim impact evidence offered in the original sentencing. Afford the victims an opportunity to submit supplemental impact statements. The victims shall also be informed of any restorative justice process that can be made available to them. I'll open the floor for comment. Any comment? Hearing none, I'd entertain a motion to receive the revised principle number 7.
So moved.
Is there a second?
Second.
Been moved and second that we receive revised principle number 7. All those, I'm sorry.
Roll call vote.
Miss Saltmarsh, yes.
Okay. Chairman Salone,
Yay.
Cheryl Ingram. All right, just hang on. I need to change my view so I can see everybody. All right, can you, okay, very good. Thank you. Kelly Cassidy,
Yes.
Robert Peters,
Yes.
Mitchell Davis,
Yes.
Ari Jones,
Yes.
Scott Main,
Yes.
Shobha Mahadev,
Yes.
Orlando Mayorkas,
Yes.
Joby Cates,
Yes.
Latoya Hughes,
Yes.
Lisa Daniels,
Yes.
Sharon Mitchell,
Yes.
Bob Berlin.
Yes.
We have unanimous approval, Mr. Chairman.
There being unanimous approval, revised principle 7 will be received. That will now take us to the revised principle 10, which reads as follows: provide a fair mechanism for the review of resentencing decisions. Again, in your email materials, you will note that there were comments as to each proposed outstanding principle. I'm not sure if we want to address those comments, but if we do, certainly we'll entertain them at this point. But otherwise, let me open the floor for comments from the body.
Scott Main's hand is raised. So Scott,
Yeah, this is, I guess, a point of order. I'm a little confused about this PowerPoint. What are, like, we're seeing two versions, like just on this one, for instance, what are we looking at other than one version, like language in a shaded box and language in an unshaded, like, I'm just curious about the layout here. So I know what we're voting on.
the unshaded language is to be edited. The shaded language is the principle as proposed.
Got it. Thank you.
In this instance, they appear to be the same. Any other question or comment? There being none, the chair will entertain a motion to receive revised principle 10.
So move, Davis.
There's
Yes,
a hand raised, actually.
I don't have, I see it, yes. Judge Ingram,
Cheryl, you're muted.
Okay. All right. The process that we're considering is actually a review of the original sentence, correct? So in this one, we're talking about a review of, are you talking about a review of a decision if it's denied, once it comes back to the court?
Yes.
good point.
So in my opinion, I don't know why we need another level of review. Because all it's going to do is stretch it out in the court, and you're going to overburden the court. I mean, once the court rules that it's either granted or denied, and it comes back to that trial judge, what level of review are you proposing?
I actually think that your original question might have been misunderstood. I think
Okay.
the two, if I'm reading this correctly, the two sentences that you see on the screen are not two separate processes. They're the same process, and the second one is just to be edited. It's not talking about another review. Is that correct?
Well, I'm trying to determine what level of review are you talking about? Are you talking about us setting up a level of review once it comes back to the court, or are you talking about a level of review after the court has ruled? I guess that's my question.
I think this principle, this one principle, is that there should be a fair mechanism for review of resentencing decisions.
Okay.
And that means once, and Scott, correct me if I'm wrong, that means once the new sentence has been applied, there should be a fair sentence. Wait, no, I'm sorry. I just confused myself. It's the original resentencing decision. There should be a fair process for the original resentencing.
Okay. Then I don't have any objections or any questions if that's what we're talking about.
So this principle applies to the original sentencing.
Okay.
Ari?
I am now also confused because in reading the original principle, the original version of this principle reads as though there shall be a mechanism for review of decisions under this provision, which may be discretionary or mandatory to ensure this process is fair. And so the phrase for review of decisions under this provision to me means that if the court denies the petition, there's a level of some sort of like appellate review. And so the revised principle would mean to me that same thing. And so am I reading this incorrectly? Is essentially we need to flesh out what this means, because it seems that I think at least three of us are working with different interpretations.
What we were basing, this principle is based on the ALI principles, and their concept was a review of the resentencing motion decision. So a denial, there would be some aspect of a review to be determined, whether it would be an appellate court review or some other judicial decision-making mechanism newly designed for this purpose.
So then that tracks then with what I believe Judge Ingram was saying, and please correct me if I'm wrong, Judge.
No, that's right. I was wrong and Judge Ingram was right. Yeah,
That's absolutely correct. I was wondering about that. If this was a review of the decision once the judge makes a decision on the resentencing.
Yeah, so the principle would guide us in recommending some type of a review process. If the consensus would be that it should not be a reviewable decision, then we would be rejecting this principle.
Okay.
And I see Scott's hand, and I don't have a full screen, so I'm going to get out of the business of monitoring hands and let the person assigned to do that without my interference. But I do see Scott, so go ahead.
So I guess I speak in support of this principle, and again, I think just to sort of keep us in the box of thinking about these as principles, that these are not these are the things that are sort of guiding and shaping kind of the overall perspective of where the task force is. And I think that we are not yet in the place in which we are hashing out details of how often these reviews might be happening or anything like that. We are just talking about a basic principle that whatever resentencing mechanism that is put forward, that there is some system of review to those decisions that are being made. And so perhaps as a clarifying point, we could say provide a fair mechanism for the appellate review of resentencing decisions, just so that we are not hiding the ball in any way, shape, or form in terms of one way forward on that. That is, as one of the comments previously had sort of noted, that our current court system, we have appellate review of other collateral type actions, 214-01 petitions, post-conviction petitions, and so it is an existent thing, and it is a process that again, we're in a fascinating thing of sort of sometimes I feel like the cart is in front of the horse and sometimes the cart's behind the horse, in terms of we are thinking both sort of in the big picture principle language, but we're also at the same time thinking about the nitty-gritty of what this might look like in practice. But as a principle, as creating any sort of path forward towards a resentencing action, I think it's important. I speak in favor of having some form of review to whatever decision happens in our circuit courts.
Judge Ingram? It goes back to
And I think my question again comes back to what I stated originally. The lower court hears the case, and you have, the right to an automatic appellate review at that point, and you have the right for post-conviction. And so then we create an opportunity to have your sentence looked at again once you served. I think we were talking about the number of years. And once that is done, the court could obviously resentence or not resentence. But if the court denies your petition for resentencing, and you have the ability to reapply in 3 years, I'm again asking, I know we have generally an appellate review, but why we're doing this and what's the plan? I mean, why are we adding another level of review when it's a program to give you an opportunity to ask for resentencing? If that makes sense.
Yes, it does, Judge.
So I want to make sure that I'm clear. The availability of a subsequent petition option is a type of review in another 3 years. So that would render appellate review duplicative, I'll say. That's probably not the right word. Is that your thought, Judge? That the judicial process is available throughout the lifetime of the person?
I guess I'm saying, yeah, you get an opportunity to reapply. I'm wondering if every time a judge denies this resentencing, why are we then creating an opportunity for another appeal on the denial of the resentencing when the resentencing program is really like a gift? It's kind of like expungements. Everybody thinks they're entitled, but it's really a gift.
And so what I think you hear from Judge Ingram is probably representative of the judiciary. And we should give it some serious consideration. Some way to work around to resolve it in an equitable manner.
Shoba, I think you had your hand up.
Yeah, thank you. I think this is another, Scott may have flagged this, but I think this is another where the devil's a little bit in the details, right? Like, I think the question is, depending on what that review mechanism kind of looks like in terms of staging out the reviews, like what kind of appellate review we're talking about, it might depend on how that's staged. So I guess my thought on this one is either we could, I don't know how people feel, either we sort of table this a little bit and go to the other one. I think we have the time period provision and figure that out, or we could think about this more broadly. I mean, to me, again, this is a principle as opposed to like actual legislation. I mean, in my view, we're looking at this a little bit just broadly, right? Like there should be some review mechanism, whether that's going to be, right after the first pass, the second pass, or the third pass. I think that's more in the details. So I guess I would be in favor probably of the latter thing I'm saying, which is to vote on this, understanding that what we mean is some sort of review mechanism. But of course, ironing out in the wash, we're going to have to figure out how that plays against the review process we're proposing in terms of, a chance to come back and file another petition. I don't know if I've said that completely unclearly, but I'll let Joby take it from there, I guess.
Joby?
Okay. I think if Judge Ingram, if this would it read better for you if it said something to the effect of provide a fair mechanism for the review of resentencing decisions with some sort of a clause or a caveat depending on the length or the number of reviews determined in specific legislation. In other words, if, for example, this group comes to a consensus that only one review in the lifetime of the person is possible, only one resentencing in the lifetime of the person is possible, then you might feel a little bit better about that one review being something that could be, there could be a fair process to review that. If it's every 2 or 3 years, you might feel a different kind of way about that recommendation. So perhaps if we put a caveat in the sentence, it would be a little bit easier to get support on.
Probably not for me, but you could change it.
Scott?
Yeah, you know, if where the task force is setting up a system in which every 3 years someone is being evaluated, I think that would be one thing, and I 100% would agree that adding an appellate level would be creating the potential for logjam. But I note that I don't think that's where we are yet. I've not heard that, and forgive me if we've already agreed upon resentencings happening every 3 years. But again, I think, you know, sort of grounding ourselves in the principles towards a system of review, I think is still important. And I raised my hand to note in terms of, you know, our other avenues in terms of what is available. There is not a limitation in terms of how many post-conviction petitions an individual can file, how many petitions for relief from judgment an individual can file. They can file, you know, petition on top of petition. There are sanctions available to a judge reviewing those if they find them to be frivolous. You know, like there are mechanisms in place to deal with situations in which if unwarranted things are being sought, but I don't think that it is enough to believe that a single level process for something as significant as, you know, again, sort of the language that we have sort of embraced in terms of the creation of this task force. Like what we are aiming for is interest of justice and creating a sentence that achieves that over time. I think it's really important that we are creating a robust system that ensures fairness throughout the operation, and is not something that can be left to that single level. So I think that it's important that we keep some system of review in place.
I heard one of the members suggest that we table this principle for a later date. I think it's a suggestion that should be given consideration. I'm sorry, Senator Peters, is that your hand?
Yes, I don't mind to say this. Thank you so much. But I think we're getting really into some deep minutia about language within a principle that seems like, I don't know if we need to table it and then come back and do this. I feel like this is, in what way does this end up, how impactful is this truly to the creation of policy? I don't know, but I think that we're putting a lot of weight on it that is concerning as I don't know how many, I think we have like 4 or 5 more left. And so I'm just worried that this is becoming a regular thing where we're really debating things to almost a minute level that are somewhat broad enough, even in definition, to appeal to people. And even if you make it smaller, I don't know how you make something like this narrower enough. But I just want to put that out here that particularly as we move forward, that principles are important, but if the weight of the principle is so outsized that we're having half-hour dialogue on each one, I don't know how productive our meetings are going to be. I think we're supposed to end at 12. And so I just want to put that out there. Thank you so much.
Chief Davis?
Yes, just real quickly, I just wanted to, I made the motion, I didn't get a second, but the purpose of me making the motion was kind of along with the line of what the senator just said. I looked at this as a principle and not a process. I think we're talking more about the process that exists right now. And, you know, this just, for me, it was a principle. So I just wanted to clarify my rationale for making the initial motion. So thank you.
Ariane?
Hi, it's Ariane, but for in terms of principles and what will guide us eventually, I would just note that even though we're currently just voting on the principles that will guide us, some of the conversation and what's been described as the minutia of the conversation is necessarily going to happen one way or the other throughout the convening of the remainder of the convening of this task force. And so some of these issues that are being raised now, while they may not be appropriate for discussing today and having more in-depth conversations at this moment, will necessarily need to be brought up at some point. And so the raising of them is not necessarily a waste of the remainder of our 3.5 hours, since this ends at 1, not 12. But also I would just encourage that we all attempt at best to keep an open mind that while this is merely the moment in which we are voting on these principles, the fact that they will guide us means that we will need to have discussions and we will need to know and be willing to discuss. Yes, there is a motion on the table to vote on the principle. We will need to be willing to have discussions about these, since these are basically the foundations upon which this task force will be moving from now on.
I agree. Any more comment? Would the maker of the motion please repeat the motion? Chief?
Yes, sir, Judge. My motion was to accept the principle that reads to provide a fair mechanism for the review of resentencing decisions.
Okay. That you've heard the motion. Is there a second?
Second.
Been moved and second. Ms. Saltmarsh, you kindly conduct a roll call.
There is a question in the chat, Chairman, regarding a motion on the table to vote for the principle as revised. I don't know that we had a motion on that, but I want to point that out to you. Scott Main suggested inserting the word appellant.
No. Oh, so no.
No? Okay.
I was this language in the shaded box, I'm calling the revised principle because it is no longer the principle. There was the principle and now there are revised principle. There was never a motion on adding language to this revised principle. I was just getting clarification that because the chief had made a motion, should we be addressing that motion before we're I'm still trying to understand process. And so I just wanted to make sure that we were acting on the chief's motion.
We are acting on the chief's motion. Thank you for clarifying. Okay, roll call. Chairman Salone.
Yay.
Cheryl Ingram.
Nay.
Was that a no?
No.
The motion is to table the principle.
No.
Okay, I just want to make sure. Kelly Cassidy.
I'm sorry, I just got confused. The motion is to table.
No, the motion is.
You know, I'm going to pass. I lost the entire thread of this discussion, so I don't feel comfortable voting. I'm just going to pass.
I believe the motion is the chief's motion.
Can we have the motion restated?
I move that the principle, my motion is to accept the principle that reads to provide a fair mechanism for the review of resentencing decisions.
Yes. Yes.
Sorry.
Is there a second? Was there a second?
There was.
Okay.
All right, Senator Peters.
Wait, I want to get clarity. So the motion is the current language I'm looking at?
Yes.
Yes.
wait a minute, actually, the motion isn't the language you're looking at. The motion is to table the language you're looking at.
No,
No,
It is-
no, there was language used here that I think was confusing. It was the motion on the table. So the motion under consideration right now is
Okay,
is the principle as revised.
approve the principle as revised. Thank you. I appreciate that.
So should we start at the
Okay.
top, Kathy? And now that there's some clarity, go ahead and do the roll.
Start the roll again.
I would, yes.
Okay. Chairman Salone,
yay.
Cheryl Ingram,
No.
Kelly Cassidy,
I'm going to continue to abstain.
Robert Peters,
Yes.
Mitchell Davis,
Yes.
Ari Jones.
Abstain.
I'm sorry, what was that?
Abstain.
Okay. Scott Main,
Yes.
Shobha Mahadev,
Yes.
Orlando Mayorga,
Yes.
Joby Cates,
Yes,
Latoya Hughes,
Yes.
Lisa Daniels,
Yes.
Sharon Mitchell,
Yes.
Bob Berlin.
No.
All right, Mr. Chairman, we have 1, 2, 3, 4, 5, 6. We have 10 yays, 2 abstentions, and 2 noes.
Okay. The yeas have it. The revised principle 10, which reads as follows: provide a fair mechanism for the review of resentencing decisions, carries. That takes us to revised principle 11. And there's only one remaining after 11. Revised principle 11 reads as follows: the issue of retroactive application of the resentencing procedure shall be clearly resolved in legislative language. Comment? Any comments?
I have a question. This is the same as the previous one where there's no change, there's no revision. So I'm a little confused as to what the actual, what is the point of what we're doing? Maybe I missed something and it could just be me and I'd be willing to accept that. But why are we why are we voting on revisions when there are no revisions?
The repetitive out of the box language is for us to make revisions right now based on the comments of members so we can see them in real time.
Got it.
So if there are no revisions, we're voting on the language as you see it on the screen. If there are revisions, we are going to plop them into that second one.
Got it. Thank you.
Any other questions or comments? Hearing
We
none.
have 2 hands. We have
Oh,
2
I'm sorry.
hands. Bob Berlin was first and then Kelly Cassidy.
Thank you. So it's my understanding we're going to have a discussion later this morning on retroactivity and the constitutionality of that provision. Is that correct?
Yes.
So, Kathy, you've received my memo on the issue. And it's my position that it cannot be retroactive. It would run afoul of Article 2, Section 1 of the Illinois Constitution. I know we're going to discuss this later.
Yes. The question in terms of this principle is whether the legislation should directly address it. The issue of retroactivity. So yes, we'll go over the points that were made, and you can elaborate a little bit more when we get to the retroactivity discussion. Kelly?
At the risk of starting us down another rabbit hole, can someone please explain what you mean by retroactive application of the resentencing procedure, since by definition, isn't petitioning for resentencing reaching back? What would retroactivity, so this feels, I mean, is it redundant? I don't understand the use of retroactive here.
As a general proposition, if legislation does not specifically allow for retroactive application, i.e. in this context, the application of the resentencing process would be available to those who have already been sentenced, as opposed to going forward, people who are sentenced after the effective date of any statute would have that avenue available to them. So generally speaking, it's a statute of statutes. If the legislature doesn't specifically state a temporal, I think, relationship is how the law refers to it, it will be interpreted to be prospective only. Now, obviously, with a resentencing scheme, particularly if there's one that specifies it's available to people who have spent 20 years in prison or more, there would be zero impact of that scheme for 20 years because it would apply only to people who are coming into the system after the effective date of the legislation. If the legislature wants it to be effective for those who are currently incarcerated, then the language would have to be clear that that was the intent of the legislature.
Okay, thanks.
Judge Ingram?
So if I understand what you say the point of the principles are, which I'm back to where a couple other people were, but if the whole point of the principles are is to determine if we're going to discuss the same thing later, and if I consider the language, the point that Mr. Berlin made, and if we're going to discuss it later, and it's a matter of whether or not we accept the principle as stated, then can we reword it just to say the issue of whether there should or should not be retroactivity should be resolved in the legislative language? And then I guess then we go back and discuss that same point again. I don't understand why we're discussing it twice, but if it's a matter of language of what we're going to discuss later, can't we say whether the issue of whether it will or will not be, whether there will or will not be retroactive application? And then it clarifies it. And then we know we go back and discuss whether there will or will not be.
I think what happened as a practical matter, Judge, is the principles was drafted. We went through on July, in our July meeting, we went through all but the 4 that we're discussing now, one of which happens to be the principle regarding retroactive application. But also what occurred was considerable conversation about the retroactive application of the statute, which gives rise to the second discussion. So as a procedural matter, we're simply trying to get through the guidelines.
I mean, the legislation could say specifically, this shall be prospective only. That resolves the retroactive question as well. So I think to make it clear that the principle contemplates both, let me suggest in response to Judge Ingram that we amend the principle to say the issue of retroactive application. I think you said, I'm sorry, Cheryl, can you restate what you said, and we can insert that language? whether or not the provision
The
is,
issue, whether or not, let me think what I said again. The issue of whether or not there is an issue of retroactivity, whether or not there is or is not an issue of retroactivity will be clearly resolved in the legislative language.
Scott?
Right. Yeah, that is it.
Okay. I'm trying to digest that new language. And I guess I raised my hand to just note that my understanding of this principle, as I read it, is that this principle is actually a neutral statement. That what Bob Berlin raised, I think, is a different question, and it is something that we are going to get to later on in this meeting, which is whether or not retroactivity, if there is a separate question of whether or not what we are proposing is going to be retroactive, versus this is simply a statement that whatever the task force ultimately recommends, like as a guiding principle, we are recommending that the General Assembly include clear language, but basically, not hiding the ball. Like when the General Assembly does decide to act, they should be very clear as to whether or not that action is going to be retroactive or not. And that comes from case law that basically says, when courts are looking at a statute, the first thing they do is they look to the plain language of the statute to decide whether or not it is going to be retroactive or not. And for instance, I was looking at the Joe Coleman Medical Release Act that passed in the last couple sessions. There is clear language in that act that this act is retroactive. So it is sort of a guide to the General Assembly that, hey, when you decide to do what you're going to do, just be clear about it. Be clear as to whether or not you want this to be retroactive. We're not yet to the point of solving whether or not it can be retroactive. We are just saying, when you decide, General Assembly, just be clear.
James Jacobs?
Yeah, yes, I think it may be more aptly stated, the prospective or retroactive application of the resentencing procedure should be clearly resolved in the legislative language.
There's some,
Orlando, you have a comment in the chat that I think is worth sharing with the rest of the group.
I was just thinking in terms of the language that's being used of whether or not retroactivity is an issue. In my personal opinion, it is an issue because it automatically excludes people from having access to, as Honorable Judge Ingram has mentioned, the gift of this process. So I guess what I'm saying is if the change in language is to determine whether it is or isn't a subject of discussion, I believe that I would hope that it's automatically recognized that it's an issue that should not need resolving, but to approach it as a mechanism of being able to provide it for all people who are incarcerated, or, hopefully we're doing our job right in preventing people from being incarcerated, but for those that will be sentenced after this recommendation, and hopefully process is available for people who are going through the system. And yes, I agree also that it can only be resolved through legislative language.
should we see if we have a motion to adopt this? Should we see where we're at?
Let me ask the state's attorney if he opposes the language in the shaded box. And that's not to middle anyone, but hopefully we can move forward if I understand his objection correctly.
Judge, the concern I have with the language in the shaded box is I don't believe that the legislature can make this provision retroactive unless they do like what the feds did a few years ago, which is to change the actual sentencing structure for the offenses. Because initially, I think it was they called it the First Act program. Initially, that was not retroactive, and they made it retroactive when they changed the actual sentencing structure. In most of those cases involved crack cocaine. So that's my position, just based on the research that we've done regarding the Constitution.
Okay. All right. Further comment? Is there a motion on the floor? I'm sorry.
No,
I'd like
there is
to-
not, Judge.
I'd like to move to adopt this principle.
Seconded.
Been moved and second that we adopt the following principle: the issue of retroactive application of the sentencing procedure.
The
Shall be
revised
clear-
language, Chairman.
The prospective. Okay, I don't have it all on my screen.
It reads the prospective or retroactive application of the resentencing procedure should be clearly resolved in legislative language.
Okay, thank you. Is there a second?
Seconded.
It's moved in second. Ms. Saltmarsh, please.
Chair Salone,
Yay.
Cheryl Ingram,
Abstain.
Kelly Cassidy,
Yes.
Robert Peters,
Yes.
Mitchell Davis,
Yes.
Ari Jones,
Yes.
Scott Main,
Yes.
Shobha Mahadev,
Yes.
Orlando Mayorga,
Yay.
Joby Cates,
Yes.
Latoya Hughes,
Yes.
Lisa Daniels,
Yes.
Sharon Mitchell,
Yes.
Bob Berlin.
Now,
All right, Chairman, we have 12 yeses, 1 abstention, and 1 nay.
The motion carries. The revised principle 11 will be received. That takes us to our final principle, which reads as the revised principle, which reads as follows: provide for the collection and reporting of data to support analysis of the process and outcomes of the resentencing. Require that judicial decision maker provide copies of its orders, both granting and denying relief, to the Sentencing Policy Advisory Council. Comment. There
Judge
being,
Ingram?
oh, okay.
Judge Ingram?
Okay, me again.
That's okay.
I don't really have a problem with the collection of data, but the judicial decision maker, is that the judge? Because if it is, you want them to provide something to who?
I think the clerk would be providing.
Then that's what it should say.
So we should change that, require that, I would say circuit clerks provide copies
of the court's order.
Of the court's order. Both granting and denying relief to the Sentencing Policy Advisory Council, which is us. We're the Sentencing Commission for the state and are tasked with analyzing sentencing policies and outcomes. So that's why we would want the orders to be able to report on how the process is impacting the system.
Judge Ingram, is that acceptable?
Yes.
Any additional comment? We ready for the vote?
I have a comment. I'm sorry. Sharon Mitchell.
Yes, sir.
So just a quick question. I worry with this change that in certain jurisdictions, specifying who would actually
provide that information?
Yeah, provide. I think it's safer to be a little bit more general, given the different places some of our counties and courthouses are at. And specifying who specifically would do it, I think this might be a mistake if we're talking about the entire state.
Doesn't each county have a clerk of the court?
Yes, each county does have a clerk of the court. I question whether each county is prepared to do this in an efficient way.
Judge Ingram?
I understand what Mr. Mitchell is saying, especially in some of the smaller counties because they don't operate like Cook County.
Right.
But somebody has to be responsible. And so you need to say who, because I think what's going to happen if you don't say it, and we had a situation like this recently, and my memory is not serving me on all the facts, but everybody was saying, well, nobody told me to do anything. Well, nobody told me to do anything, so nothing got done. And that's in Cook County. So if you don't say who's supposed to do the job, it won't get done. And
I totally agree with the judge. And I think that when we're talking about kind of specific mechanisms, at some point we should specify who. But to me, and this kind of gets back to the conversation we were talking about before, as a general principle, is this a general principle or is this a directive? And I think that it might make sense for us to stay general when we're talking about principles and be a little bit more specific when we're talking about, the actual rules that this action will be guided by. But I don't feel super strongly about this. I just, given my experience, I just in my, the work we've done statewide, I worry that if you specify the actor, you might run into some trouble. But I understand what Judge is saying, and I'm open to both interpretations.
Well, can we say a process should be established to provide the information?
Yeah, I think that sounds really good. Yeah.
A process should be established, maybe.
Scott?
Jerome took all my thunder. So we're in principal land, and I just want to make sure that SPAC's getting the data they need, and I will let Rep. Cassidy and Senator Peters and their friends figure out the right language for actual legislation.
Any additional comment?
Nope, that's good.
All right. Ms. Saltmarsh, portions of my revised principle are cut off. So would you read it?
Yes. A process should be established for the collection and reporting of data to support analysis of the process and outcomes of the resentencing process, including providing copies of the court's orders. Both, I would just say court's orders, Abigail, let's get rid of to the Sentencing Policy Advisory Council.
Yes.
Thank you. That is the proposed revised principle. Is there a motion to receive it?
I'll make the motion to receive it.
I'll second.
It's been moved and second that the revised principle be received. Ms. Saltmarsh.
Chairman Salem,
Yay.
Cheryl Ingram,
Yay.
Kelly Cassidy,
Yes.
Robert Peters,
Yep.
Mitchell Davis,
Yes.
Ari Jones,
Yes.
Scott Main,
Yes.
Shobha Mahadev,
Yes.
Orlando Mayorga,
Yes.
Joby Cates,
Yes.
Latoya Hughes,
Yes.
Lisa Daniels,
Yes.
Sharon Mitchell,
Yes.
Bob Berlin.
Yes.
Unanimous support, Mr. Chair.
There
Thank
being
you.
objection, the motion carries. Revised principle number 12 will be adopted. That takes us to the portion in our agenda regarding retroactivity. I'm going to ask that Ms. Saltmarsh start that conversation.
Thank you. First of all, I want to say thank you to the attorneys who provided their very, very good legal analysis on the issue of retroactivity. It seems we heard from Bob, and he's raising a question that I think that we need to get into and discuss in a little more detail. I'm going to be a bit more general. The case law that was presented by the majority of the memos that I received indicated essentially that the legislature, if it expressly says in legislative language, imposing retroactivity, well, retroactive application, that language is to be given respect, essentially. So there are tests if there are questions and if it's unclear in the legislation whether or not it's to be retroactive. There are tests in the case law that would be applied. But if there is clarity, retroactive operation is not per se unconstitutional. It can become unconstitutional if it interferes with other due process rights, or, as was raised in a previous meeting, potentially contract rights. So as a general proposition, it seems the majority view is that retroactivity is an option here, but it must be clearly stated. Then, should a challenge be mounted in a particular case or to the legislation, the questions of constitutionality would be resolved in terms of whether or not that retroactivity interferes with other constitutional rights. That is a very, very, very nutshell summary of the very, very good legal work that we got. So I would think I should just say I will leave it to the members to discuss this more fully. But I will also remind the members that, hearkening back to our initial meeting where we looked at the prison population. The majority of the folks in our prison population are there on long-term sentences, and there is no prison population impact to a provision that is prospective only. So I will turn it over. We do have a draft recommendation, and Scott actually has raised his hand.
Yes.
So I guess I speak in support of this recommendation, and I begin with repeating back what we heard from Task Force Member Orlando earlier, that that the work that we do and the recommendations that we make should be addressed to those who are currently serving as well as moving forward. And so I think retroactive application of these resentencing opportunities is critical and important. And if I understood State's Attorney Berlin's comment earlier when looking to the federal model, there are ways to do it, and we just have to do it correctly. And that is my understanding of the case law. And I still have not found the thing that says that Illinois, that there's something unique about Illinois that would prevent it from pursuing a retroactive sentencing opportunity in the way that other jurisdictions have. So we have elevated the federal system through crack cocaine disparity that has created resentencing opportunities. Again, when clearly stated, it can be done. And so my understanding is that there will be a lot of work to do to work this out, but that I don't see that the separation of powers doctrine found in our Constitution bars retroactive legislation. It just has to be clear that we are not infringing on, that the General Assembly can't be infringing on the power of the judiciary and can't be infringing on the power of the governor. And language of the act can make clear that it is not doing that resentencing can exist at the same time as clemency, just as we are clear that we are not overlap, or we are not duplicating. We are creating a different matter, and for the same matter in terms of the General Assembly and the judiciary, the General Assembly is not telling the courts what to do. They're just permitting the courts to do something. And so that is my understanding of how our separation of powers doctrines work. And I don't see it as an actual bar to retroactive, a constitutional bar to it. It's a policy conversation.
Any additional comment?
Bob Berlin has his hand raised.
Thank you. So, yeah, thank you. So just a few things. I mentioned earlier the constitutional issue, which our position is it's the governor that has the exclusive power on these matters. And when we go back to what happened in the federal system, initially Congress passed the Fair Sentencing Act to address the disparity between sentencing guidelines on crack cocaine charges versus cocaine. When they initially did that, they did not make it retroactive. Subsequently, they passed the First Step Act, which made the Fair Sentencing Act changes to crack sentences retroactive. And it permitted those convicted and sentenced for qualifying offenses prior to the Fair Sentencing Act to then seek resentencing. But when they did that, they changed, again, the sentencing scheme for crack cocaine. So, if the plan is to have legislation that actually changes the sentences for many of these violent crimes, that's another discussion. The other issue is the issue of contract principles. And it, this is something I brought up earlier, and that is both the defendant and the state receive a benefit when there's a plea bargain. Typically, the state makes a number of concessions, including dismissing certain counts or charges, or in some cases agreeing to a sentencing cap, or agreeing to amend charges before a plea of guilty. And I would point out that our position is, if there is a resentencing, we believe that a defendant would then be entitled to file a motion to withdraw their plea and or reduce their sentence, again, under current law as it is right now. So that's another concern we have. The last thing I would point out is, I understand what the goal is here of reducing prison population. I would remind the committee that not very long ago, we had 48,000 inmates in IDOC. We're down to 27,000. And I don't have the percentages, but most of them are in for some type of a violent crime. But understanding what the goal is, we still have to follow the law. And in order to achieve that goal, my position is we can't run afoul of what the law is. So that's the analysis that we've done, and I've had a number of people working on this issue.
Shobha and then Ari.
I'm going to speak in favor also of the principle. Number one, I want to say again, it's a principle, right? So I think, once again, in terms of the details and, as they say, the sausage making and all of that, I leave that to our esteemed members of the General Assembly to work that through to ensure that legislative intent is clear, which I do think is sort of the agenda when you're talking about retroactivity. I want to also chime in that my students, colleagues, people, defense attorneys and attorneys at law firms have researched this retroactivity issue for almost a decade at this point. And we agree that there is no bar per se. It is a matter of how we draft it. To the extent that there may be concerns about separation of powers and things like that, those can be, I think, worked around. Those are not bars. Those are just things to be aware of. I think for our purposes, based on the research I've done, and the research my colleagues and other folks we've sort of tapped into have done as well. So I would say that this is an important principle for us to be mindful of, given that the people serving right now are people with very long sentences, and that there are limitations to what they're able to access at this point. And I think that is, in many ways, cuts at the core of what this task force is aimed at. So I'd urge a vote in favor.
Ari.
Thank you. Just a few things. So as to the separation of powers issue, well, first, I agree with everything Scott and Shobha have said. But as to the separation of powers issue, I know there's the Illinois Constitution, Article 2, Section 1, but even the Illinois Supreme Court has said that this doctrine wasn't designed to achieve a complete divorce among the three branches of government. So there's meant to be some overlap. So there is never going to be a clear distinction between executive, legislative, and judicial, really in any portion of any government in any state or even on the federal level, but certainly here. So the fact that there may be some overlap between this proposed process and the governor's clemency powers does not make this per se an unconstitutional venture. In terms of the governor's clemency powers, while there may be some overlap, it doesn't amount to that violation of separation of powers. The governor's clemency powers are far more vast than simply commuting a sentence. He has the power to grant pardons and reprieves. He has the power to declare a person innocent. He has the power to commute a sentence to below the mandatory minimum, things that are far more broad than what is being proposed here beyond the mandatory minimum thing, which I think we'll get to a bit later. And so this very narrow exercise in allowing resentencings, which already does happen in courts, is, from my perspective, not a violation of separation of powers. And in terms of retroactivity, it's not really a favored thing by some, certainly, but it's not unconstitutional as long as it's explicitly written into a law. We run into issues when we try to interpret something as retroactive and the legislature has not explicitly made it so. But outside of that, there's really no issue with that. And that too comes from research both within the state, that including Commonwealth Edison Company versus Will County, and some federal case law. So that's all. Thank you.
Robert?
Just want to make a motion to pass.
Second.
There's a motion on the floor. Is there a second?
Second.
Been moved and second that this committee received revised principle 12, which reads, oh, I'm sorry, Ms. Saltmarsh, can you read the?
We are actually talking about a recommendation. And the recommendation is, the task force recommends the Illinois General Assembly pass legislation to create prospective and retroactive resentencing opportunities.
Yes.
So this would be our first recommendation.
Motion to move to pass this recommendation, I think, is the right motion here.
I'll second that.
It's been moved and second. Can we put that on the screen, the motion itself, or no?
Abigail, we're to the recommendations, not the principles. There we go. Thank you.
Okay. Right, it's been moved and second. All those in, I'm sorry, Ms. Saltmarsh, would you conduct the roll call?
Chairman Salone,
Yay.
Cheryl Ingram,
Yes.
Kelly Cassidy,
Yes.
Robert Peters,
Yes.
Mitchell Davis,
Yes.
Ari Jones,
Yes.
Scott Main,
Yes.
Shobha Mahadev,
Yes.
Orlando Mayorga,
Yes.
Joby Cates,
Yes.
Latoya Hughes,
Yes.
Lisa Daniels,
Yes.
Sharon Mitchell,
Yes.
Bob Berlin.
No.
All right.
Was everyone polled?
There's 13 yays, 1 nay.
All right. The yeas carry. The recommendation is accepted. At this point of the agenda, we provided for a 15-minute break. I suggest we do that and reconvene at 11:45. Is that okay?
Okay. Comfort break, everybody.
Actually thought we had 1 minute more, but okay.
Oh, you're
Hey.
right. You're right.
Is everyone back?
I think everyone is back though.
Okay, all right. If everyone's back, we can start. Okay, according to the agenda, we are now at the process and procedure and resentencing phase of our discussions. Ms. Saltmarsh?
All right. I would just want to take a moment to kind of harken back to the first meeting that we had, and remind all of us about that robust discussion, the questions that we were addressing, and also the interests that we identified as those to be weighed in terms of coming up with recommendations. And I'm going to just touch a little bit on the research around public safety and incarceration, which we had some references to what I'll be talking about in our materials for that first meeting. But I think it's important that we understand where we are in terms of criminology's analysis of crime and sentencing. So, obviously we began with our enabling legislation and got from Kelly and Robert a little background on, the issue around fairness of having a resentencing process that was only in the hands of state's attorneys, and the fairness issues that raised in jurisdictions where the state's attorneys weren't going to be filing or even considering resentencing motions. Although we have several jurisdictions where they are and where they are responding, I think, in some form to inquiries. But we kind of had three big buckets of questions. The first is how we weigh the interests affected by changes in sentencing policy and practice. Who should be eligible for sentencing review. And we talked in that context of how the crime of conviction and the time already served should be accounted for or considered. And then what is the process? What are the issues that need to be resolved, and kind of the mechanics of how this would work? At the end of that discussion are the interests that we had identified, where the community interest in public safety, the victims and survivors' interest in subjective justice for their individual case, community standards around punishment, retribution versus rehabilitation, fairness, all of those things. And in the Constitution, we have the purposes of sentencing laid out pretty clearly. And how do those play into this? Then the interests of the families of the incarcerated and their communities, which does link back to public safety. We touched on the power of restorative justice to actually provide victims with an avenue of healing. And also we touched a little bit on the economic impacts of mass incarceration. Rehabilitation was front and center, and we talked at some length about the fact that people who are incarcerated for a long period don't necessarily have access to programming, but they still manage to grow and change. And we noted, I think there was no disagreement with the basic premise that human beings do change over time. We've all been through that recently. And then the really practical resource question of, the systems need to both resolve cases efficiently and produce positive outcomes. So that's kind of our philosophical foundation for moving on to talk about recommendations. And so now I want to talk just a little bit about where we are in terms of general knowledge, I'll say, around recidivism and sentencing and crime patterns. And the most in-depth seminal work on this issue in recent times was done by the National Academy of Sciences. It was a group of about 20, it was over 20 experts from a diverse number of disciplines, and they looked at the relationship between crime and sentencing. And basically, they reiterated what decades of research has shown in terms of general deterrence impact of sentencing. And general deterrence is you sentence person A, and that is going to deter people B, C, and D in their community from committing crimes. And basically, the criminology is very clear, and has been clear for a long time, that effect simply does not get produced by harsh sentences. You have specific deterrence, which is the person who gets sentenced hopefully doesn't want to do it again and go back to prison. And then you have the thing that prison does the best, which is incapacitation. So those are the three results of sentencing that we have. But the sad, I think, conclusion that they reached was what we've seen in terms of decline in crime is primarily due to things other than sentencing. Experts estimate between 10%, actually less than 10%, and up to maybe 20 to 25% of the decrease in crime is due to sentencing. But we have to understand, and this task force should understand, that that is the caboose on a very long train. And it's very clear that what comes before will have a greater impact over time on public safety than attempting to establish safety through more harsher sentences. And we have, you know, I think the most general, there are two very general primary expressions of extreme sentences, and those are mandatory minimums and the truth in sentencing laws, which operate at two very different levels. With mandatory minimums, the ability of a judge to consider the characteristics of the person at sentencing is minimized and sometimes eliminated. And the most in-depth study on mandatory minimums came from the Federal Sentencing Commission probably about 6 or so years ago, where they reviewed 72,000 cases and found that mandatory minimums were neither mandatory nor minimum, because people who are in these cases are human beings, and the courtroom actors will come to a place where they reach what they feel is a fair and equitable resolution in a case. And sometimes that means making decisions about changing charges or putting people in programs that takes them out of that category of mandatory minimum. And then truth in sentencing, you know, that is a limitation on the Department of Corrections' ability to award sentence credits. And that is the one thing that contributes significantly to the type of population we have in prison today. Then the final thing is we are all concerned when it comes to public safety about recidivism. And SPAC has looked at recidivism over the years. National studies that look at recidivism kind of establish what we've known for a long time. When it comes to the worst crimes in the worst neighborhoods, it's a very small percentage of people who are responsible for 80% or so of the worst crimes. When we have looked at people coming out of prison who had gun charges, murder, we see a recidivism pattern that is a small percentage of those people will go on to reoffend in a more violent, serious way. But the vast majority of recidivism will stay where it has been for a very long time, in drug and property crimes. And I don't mean to minimize the impact of recidivism, because it is very costly to our communities and to our prison system. But when you look at the recidivism rates of violent criminals who are released from prison, they have very low recidivism rates. And when they recidivate, they are most likely to not commit another violent crime. And finally, we have resource allocation. It is a truism, and it makes no sense that the money and the people do not flow through the system at the same rate. But what we do know is that we're spending, I think the budget for DOC in this fiscal year is $1.647 billion. And we are making efforts on the front end to put more money into communities and strategies that build community health, the social determinants of health. And we are hoping that the Department of Corrections can do better with programming, but we need to be honest about the costs of running the prison system that we have and the likelihood that's going to be something that will happen in the near future. Even though they are making great changes, I don't want to minimize that either. But when you look at resource allocation and you talk about return on the tax dollar that is invested, we get far greater bang for our buck if we invest in the services that are necessary to allow communities to thrive without having to access them through the criminal justice system. So in the context of all of that, and in this new era of creating a new mechanism, we can get down and start talking about eligibility. But I'll ask if anybody has any questions or comments. Not seeing any hands. So Chairman Salone, I'll hand it
Okay.
back to you.
All right.
I'm sorry, can I make a comment, please?
Sure.
Thank you. I'm sorry, Chairman. Couldn't find my raise hand button there quick enough. Just want to make a statement. I know that with this subject matter and me being a law enforcement person, there are going to be, I will have colleagues and others who will be, what the heck is he doing? Why is he being supportive of these efforts? And I just want to make it clear that, I, having been the past president of Illinois Chiefs Association, I made this clear to the membership of our association that I bring a different perspective than many of my colleagues. I bring the perspective of being a Black man in the United States. And for me, I have a responsibility that there are inequities that exist in communities of color when it comes to sentencing. I'm not, as a law enforcement officer, I am all about the victims. I'm all about holding people accountable, but we need to be equitable in how we hold people accountable. And I know that there have been inequities that have existed for forever as it pertains to communities of color. And it is my responsibility and my thought process that I'm not looking, law enforcement will be, they're just looking to release everybody, let everybody out of jail and wreak havoc in our communities. That's absolutely not what I'm talking about. The last thing that we voted on was to put systems in place. And putting systems in place with the focus on equity is the reevaluation of how things were imposed upon everyone. And if there were inequities in doing so, that they be righted. And that's what the totality of a system can help with and help to come to fruition. So, I stand on what I believe in. I stand on the things that I vote for. So I have no reservations about that. But I just kind of wanted to make that commentary to let folks know that, I'm doing what I believe is right from my lens. My lens is not the same as everybody else's. And if folks don't agree with that, then they'll be okay. So thank you for allowing me to say that.
Sure. Actually, if I may, dovetail that. I said earlier in our earlier meetings that this notion of equity has to find a place in our process. And I think it's been abundantly established that there have been and continue to be inequities in the system. What attracts me most about the possibility of resentencing legislation is not the notion that we're going to reduce the prison population. Quite honestly, I think the taxpayers would just as soon pay whatever costs to keep a person incarcerated. And so I don't really know that that's first and foremost on their mind. What I'm attracted to is the notion that as science evolves, particularly in the area of mental health and criminal justice reform, a resentencing provision affords the system an opportunity to correct some inequities. And so it really is a question of, I hate to say this, but it may be a question of political will. But it is something that is long overdue. And just to simply couch this movement as an effort to reduce the prison population, I don't think, it's my personal opinion, is first and foremost on the mind of our citizenry or our legislature. So with that, let's consider the eligibility recommendations. And there are two of them.
Chairman, there's a hand up.
I don't see it.
Orlando Mayorga.
Okay. Yes, sir.
Thank you. I'm Orlando Mayora. I just wanted to share that some words that are sticking out to me in the comments that have been made by Kathy and by Chief Mitchell, as well as Honorable Judge Sloan, has been the word humanity and the word of public safety. When it comes to public safety, I think some of the things that aren't captured by recidivism is just the identity crisis that a lot of people face, both young people here that are out here in the community and also on the inside. One of the greatest struggles that we had and just to be vulnerable with everyone here, like I spent 20 years in prison. I was a 17-year-old who was sentenced to 48 years in prison. I was able to get a resentencing appeal in. The judge then gave me a 40-year sentence to serve 20 years, but this truth in sentencing and mandatory minimums would have kept somebody like me to realizing my best self in the space that I'm now in. And it would have kept many others like myself making a difference in public safety issues in the community from realizing our best selves and preventing other young people from going into the system. So when it comes to the humanity issue and the public safety issue, I think we do a disservice to our larger society, to our communities, by preventing people from being able to realize their best selves because of a mandatory minimum or because of having to serve 85% or 100% of their time now. I'm happy that I'm in a space where people are actually reconsidering the damage that has been done by laws that keep people punished in a state of isolation, in a state of incarceration, because the benefit that I had and the privilege that I had, also the luck that I had in being in facilities that had plentiful programming. And this is only 3 facilities in the state of Illinois that have higher education in prison. But not only it being about earning credits toward a degree, but to actually have the spaces to do the introspection, to grow and understanding accountability, and to really use the remorse factor to want to change the community when we come home. But these truth in sentencing laws keep people incarcerated from making that difference. And I just want to make sure that people know and understand that that I truly believe that those who have been the problem have the solutions and are going to keep chipping away at this problem, not only of recidivism, but also from keeping young children, youth, both male and female, from entering the system and having to keep doing this constant revolving door of trying to fix a system that I hope can be fixed. But at least for us that are out here, being able to provide a different pathway for seeing the world that we want to imagine and really envision.
Thank you. Any other hands? Okay. Concerning the question of eligibility, there are 2 issues that have been raised. First, the petitioner must be serving an aggregate sentence of at least 20 years, and second, must have served at least 10 years of that sentence before being eligible. There, I seem to recall there may have been some issue about age of the petitioner as well. But at this point, these are the 2 threshold criteria, and I'd welcome some comment regarding these 2. Mr. State's Attorney.
Thank you very much, Judge. You know, let me just start out by saying that we're talking about concepts of crime and punishment here. I would point the committee, and Kathy, I know you're familiar with this study, which I constantly go back to, University of Chicago Crime Lab study in 2013, which was a SPAC article that did a study on sentence enhancements for unlawful use of a weapon. It concluded that sentence enhancements, in fact, reduced crime. It noted that in a particular year in Chicago, over 63% of probationers and on probation for unlawful use of a weapon were rearrested for some crime within 12 months, with 7% are rearrested for a violent crime specifically. You know, we're talking about the cost of incarceration, and clearly it's a significant cost. But there was a study in 2017, Cohen and Miller, out of Vanderbilt, that concluded the cost of crime to the country is $2.6 trillion a year. That was their conclusion in 2017. There's a huge cost to society, and it's not just the victims who have a subjective interest in punishment or justice, but the entire community has an interest in punishment. So, and when we talk about truth in sentencing, one of the aspects of truth in sentencing is transparency. And I think, you know, obviously there's been a huge push for transparency in government. I support that, but I think it's very important that the public understand when someone is sentenced, what the sentence really means. Is it 50%, 75%? But the idea that someone could be eligible for resentencing in 10 years, what is that going to do to society? What is that going to do to witnesses in their desire to participate in the process? We have a difficult time in many cases getting witnesses to come forward now because they're afraid. They're afraid if the offender gets out on bond. They're afraid if the offender gets out after serving a sentence. It's going to have a huge impact on our ability to prosecute cases with someone who would be eligible for a resentencing after 10 years, and to put the victims through that process and have them re-victimized. I'm very concerned about the effect to public safety with a resentencing after 10 years.
Joby?
Yes, you know, while I appreciate that perspective, I think one thing that it's really important to do in this moment, I think, you know, Kathy Saltmarsh has already noted all the studies that really kind of undermine some of Mr. Boleyn's statistics just now. I mean, there's just a much larger body of evidence, both local and national, that this problem isn't described well by that previous short list of studies. I do think, however, where data is lacking and where fears about witnesses not coming forward, fears about 10 years being too soon because folks won't participate, or what will this do to society? I think those fears are quite overblown, because we do actually have a system where a good number of people serve less than the mandatory minimum and don't have to rely on these things. And in those cases, it's because they've cooperated with the prosecution. What we see, Mr. Boleyn, 20, 30, 40 years later are the people we work with. 20, 30, 40 years later, we see the younger co-defendant. We see the co-defendant who really didn't feel as guilty in this crime, but was someone who was a little bit older and a little bit smarter, made a deal and they didn't. And so they're the ones who are still in prison at 30 and 40 years later, not the person who made the deal. There are always people committing horrific crimes who are going home after 10 years, who never get caught, who get caught and get out of it. So the idea that a process after someone has served 10 years in prison in the Illinois Department of Corrections, where for certain offenses, you're going behind the wall and you are going to have to look at yourself in a way that I would argue no one on this particular task force, save Orlando Mayorga, has done. You're going to have to look at yourself and you're going to come out a different person. I've hired 7 of those people full time who've done more than 20 years in that system. And I found them to be far more thoughtful and mature than most of the folks traditionally trained out there. So I just want to argue that there's a real advantage to having a process where a human being can have a chance, not a guaranteed release, but a chance. And that many things have changed after 10 years, including, in my experience, the dynamics of the situation itself that caused the incident in question. I speak in strong support of this recommendation, and I'm happy to move it to a motion at any time.
Robert?
Thank you so much. Let me lower my hand while I talk. So I just want to say that there's a few things that I find concerning about the penalty enhancement sentencing situation, is because I remember the debate in, I think it was 2016, over a gun penalty enhancement that I was told would lead to a reduction in gun violence. I think we were all told this, and that Eddie Johnson said that over the next couple of years, it would lead to a 50% reduction in gun violence. And then I was told last year about how we have issues with gun violence. So it seems like that statement didn't actually happen, right? Nothing happened there. Then I also see, as we see all this gun violence, talk about these individual actors and particularly violence, and seem to avoid a whole bunch of other material conversations that happen, which makes me think of places like Norway, which don't have nearly as much harsh sentencing as we do. And judging by the statements that we make about sentencing, I'm guessing it's complete, total damning anarchy in Oslo every day, because they don't have the strict sentencing structures that they need to have. And so thinking about this conversation, I truly believe all of us should send prayers to Oslo for having such an anarchy system when it comes to sentencing, or to Germany, or to Finland, or to a host of other countries that don't have nearly as much harsh sentencing as we do. But from my vantage point, from what I see, it turns out it might not be sentencing. It could be the housing policies of Vienna, or the fact that you're getting wraparound services in Germany, and a variety of other good wages in Norway, and using budgets in a good way for people. But considering what I've heard, it seems like it should be total anarchy in Northern Europe on a regular basis. And I send prayers to all those people over there. So thank you.
Ari and then Lisa.
Yes, thank you. I won't comment really on the policy side of things in terms of arguments for or against this proposed recommendation. My greater concern is the second portion, that the petitioner must have served at least 10 years of their sentence. I understand that the petitioner must meet 2 criteria to be eligible for a sentence modification. My concern, however, is that for petitioners who are serving sentences where the mandatory minimum is above 10 years, for instance, first-degree murder carries a mandatory minimum of 20 years, if a judge can't modify that sentence to be anything lower than 20 years. So if you're serving 20 years in prison and it's for first degree murder, there's no way to downwardly depart from that. Illinois appellate and Supreme Court law has repeatedly stated that only the legislature has the ability to modify penalties in that way. And when you do allow for the option for the court to depart below the mandatory minimum, what you are now doing is infringing upon the governor's clemency powers, which does then raise separation of powers questions. And so I'm very concerned just about what the phrase modification means, and then what and how this would be interpreted in terms of the second clause of this criteria.
Lisa?
Thank you. I wanted to speak to the concern that Mr. Berlin expressed about the victims and survivors, excuse me, and the witnesses coming forth. I wanted to offer the consideration, or I'd offer you to consider, Mr. Berlin, that there's a growing movement of survivors of violent crime who use their voices in a different way, who use their experiences in a different way, and consider less that fear-mongering ideology that says that we as survivors are all afraid to come forth, or even expressing to us that we should be afraid to come forth in an effort to further the prosecutorial effort. I think it's important to understand again that there's a survivor that is not afraid to come forth and does not see long sentences as the justice that is needed or deserved in order to in an effort to heal and to move forward. There is a movement of survivors of violent crime that understand that many individuals who commit violent crimes themselves at one point in their lives have been victims as well. There's truth that hurt people, and it's important to respect, I think, the voice of the survivor of that crime. Respect the fact that we are clear about what we want, and that not all survivors of violent crime are seeking punishment and shaking in their boots when it comes to utilizing their voices. I just wanted to make that clear. I just wanted to make that clear and use this platform as an opportunity to, I guess, do what I was invited here to do, which is be the voice of the survivor of violent crime.
Scott, and then Joby, and then Sharon. Scott, you have to unmute.
I know. Yeah, you should have heard what I said. What I'd said just a minute ago was amazing. First, I want to thank Lisa for what you shared, and also I just wanted to react a little bit to what Ari had brought forward regarding the second principle here, so two things. One, and this again circles back. We're in our cart horse situation of talking about one thing without having yet talked about the other, which is that what Bob Berlin had mentioned earlier, to solve for some of these constitutional problems might require adjusting our sentencing structures. And again, that's something the General Assembly gets to do. The case law that Ari points out, the General Assembly is the one who sets punishments. They set the lengths and the times, and so it is possible that is a decision that could be made in crafting a resentencing statute, would be to create some ability to make a change or a shift, a broadening of discretion where currently there is no discretion. But let's say we don't do that. The task force has already voted and supported a recommendation that provides for screening and dismissals of applications that lack merit on their face. And so if nothing happens regarding mandatory minimums and someone files a petition after 10 years and they're serving a 20-year sentence that a judge can't deny or can't do anything about, then we've covered that. We've handled that situation. And again, I think more is possible, and I think that it's worth us digging into that. But I think either way, it's not something that should prevent. And so I will end just in thanking the SPAC and the task force for coming up with these topics for us to talk about, because you know, there's more people that I think we want to be sort of focused on, and this at least gives us a entry point to have this conversation.
Joby, Sharon, and then Bob.
Yeah, and I'll just say really quickly, one thing that I think is maybe not totally intuitive about having a sentence adjustment. There are actually quite a few of the former juvenile life sentenced folks who got resentenced to a term of 10 years or more that they hadn't already served. In other words, they were given life without parole. The U.S. Supreme Court deemed their sentence unconstitutional. They got a resentencing, and the judge said, okay, well, you had life, now I'm giving you 60, which, because it was pre-truth in sentencing and it was 1995, you're going to do 30, and you've only served 20, so you have 10 more years in prison. And so you might think that doesn't mean anything, or it's not going to do anything. And I think I just wanted to make I think I think everybody knows that sort of, but it may not be totally clear how many of the policies at the Department of Corrections are geared toward driving resources and opportunities to people who are getting closer to a release date. So if you know you have an out date with 10 years to go, you can have a very different 10 years of incarceration than if you don't know until a week before, a month before, a year before. It changes the math. It changes where you do your time. It changes your access to programming. And in many cases, it changes your mental state and your ability to maintain hope and positive daily behavior, which we all know is important. So I'll stop there. Just wanted to make that quick point about, I would like to change the base sentencing structure too, very much so. But given that the purpose of this task force is around resentencing, I thought I would just make that quick point.
Sharon, and then Bob.
Yeah, thank you all so much. You know, I think that we need to be honest about the limitations of our sentencing process. When we make a decision about someone, whether that person is serving days or weeks or months or years or decades, it is a snapshot of a certain person at a certain time based on a certain act. And how that person develops as a person, what assistance they will receive in that development, isn't known to the persons that are making the decision at that time. I mean, I think we have to be very honest with ourselves that sentencing is a guess. It may be a well-intentioned guess, it may be a well-informed guess, it may be a well-established guess, but it is in fact a guess. And sometimes that guess is right, sometimes that guess is proper, but sometimes that guess gets it wrong. So there's no doubt that there are value in norms, in predictability, and in transparency. But I just think that denying the fact that there may be instances where we should look at a new decision, I just don't know if I understand where we're at. And here's an unrelated point. I think we also have to be honest with the political reality of resentencing. The idea that if we create a resentencing scheme here and it's on the table, that the doors of the prison will be open is just a political reality that I don't know.
Right.
We've seen supremely modest efforts to look back at a handful of people, supremely modest efforts, to be hit with the winds of a political backlash that could knock over a skyscraper. We're talking about developing a process that includes victims, that provides transparency. This isn't an effort that denies that harm happens, that people can do bad things and hurt people. It doesn't deny that accountability matters, but it also doesn't deny that sometimes decisions are wrong. And sometimes it's just a snapshot in time, and that perspective can change. That's all I got.
Bob?
So I just want to add, I mean, and Sharon, I don't disagree with what you're saying, but I do just want to address a comment that was made earlier. The purpose of what I'm saying is not fear mongering. That's not what this is about. It's just about concepts of justice. You know, I've been doing this for 35 years. I regularly meet with victims of crime every single day, and have tremendous respect for survivors of violent crime. The point I was trying to make is people are afraid to come forward. People are afraid to testify, especially in gang cases or domestic violence cases, because of a fear of retribution. It's a real fear that we as prosecutors deal with every day in trying to obtain justice in these cases. So the concept of resentencing, I don't necessarily disagree with, but when we're talking about 10 years for child rapists or murderers or perpetrators of horrible domestic violence, I just, never mind the political reality of that. I'm just talking in terms of coming from a justice point of view, in a fairness point of view. I just think we also have to look at the other side, at what these crimes do, not just to victims, but what they do to entire communities. Because there is, you know I'm not the only one saying it. People are genuinely afraid right now. And there's, violent crime is up everywhere. And I'm not saying that the criminal justice system is the only way to deal with that. Clearly, it's only one factor, and there are many other reasons for it. But my whole point is that I think we need to acknowledge the impact that these crimes have on the community.
What would his number be if not him?
Was there someone else?
No, I think that's it, Chairman.
Actually, Lisa Daniels has her hand up.
Daniels has her hand up. Thank you. I'm wondering, we've talked a lot about the fairness or the potential fairness of the criteria that's in front of us. And I get it. And so my question would be, as it relates to these criteria, is this the minimum criteria? Or are there other things that need to be taken into consideration? As a petitioner, can I just present that here I am? I have a sentence of 25 years and I've been here for 12. Am I eligible under those circumstances? The answer here is yes. But what are the other criteria that must be considered in order to for resentencing to be an option? And I ask that question because I get that there are systems, there are spaces where justice needs to be had. But if a person has served 12 years of a 25-year sentence and has completed tons of programming, has shown him or herself to be a completely changed human being, are those things that are taken into consideration when considering resentencing?
Can I interject? And I think it may kind of address your question, Ms. Daniels, and also the some other comments, concerns. And it's really quite simple. And Ms. Kate said it, that the filing of a petition does not automatically bring about relief. I have supreme confidence in our judiciary. I think those men and women are best positioned to address the current circumstances of the petitioner as it relates to, or as opposed to, the time of sentencing. And so these are minimum recommendations, but ultimately a judge is going to consider all of the implications, the impact on the community, and the impact upon the victim, the impact on the defendant, the petitioner, and the petitioner's family. And I think they take that charge quite seriously. That's been my experience. And we shouldn't lose sight of that. And I'd like to hope that our judiciary, we can vest our judiciary with a bit more discretion than currently exists.
Thank you, Judge Salone.
Orlando?
I wanted to offer a comment on something Mr. Merlin said earlier about the effect upon the affected community. But I'm also, I guess, going to ask a question to everyone here. Like, are we considering also the reverse effect that the criminal legal system or the court's impact has on the community? Because, and I ask that because nowhere within the current criminal legal process is it centered around repairing relationships between a person that may have allegedly done something and the impacted family. So what I'm saying is, the way that it's done, the way things are done, is it just puts people away without having in any way addressed the harm that has impacted a community, and just sentencing people to long terms, which I believe that this is the ongoing discussion, without any form of process to be able to repair that or repair the relationships, is also just as harmful, I believe, to society and to a community.
Okay, I believe there's a motion on the floor. I don't know that it has been seconded. We embarked on comment, but the motion, and correct me if I'm wrong, reads as follows. Well, I don't know that I have it all. Petitioner must meet two criteria to be eligible for sentence modification. One, the petitioner must be serving an aggregate sentence of at least 20 years. And two, the petitioner must have served at least 10 years of their sentence. That was the motion as I recall it. Is there a second?
Lisa?
All things considered, would the body consider making a minor change and in this criteria here and change it to read petitioner must meet two minimum criteria? That way there's room for all of the other things to be considered.
Maker of the motion, would you accept that modification?
I don't remember who made the motion, but if it was me, I would.
Well, it must have been you.
Well, there you go.
Okay.
Is there a second on the modified motion?
I second.
Did you propose the modification, right? No?
Yes.
Okay.
Yes, I did.
Okay,
I cannot, okay.
I don't think so. Someone else second it, please, or it'll die for want of a second. So we can vote it up or down. Okay,
I'll second.
thank you. It's been moved in second. Ms. Saltmarsh,
Chair Salone,
yay.
Cheryl Ingram,
Yeah.
Kelly Cassidy,
No.
Robert Peters,
No.
Mm.
Mitchell Davis,
Oh.
Abstain.
Ari Jones,
No.
Scott Main,
Yes.
Shobha Mahadev,
Yes.
Orlando Mayorga,
I will abstain.
Joby Cates,
You have to unmute.
Love it.
I'm not sure if, I think there might be some confusion about the new language, and maybe I'm like to withdraw my motion so we can talk about what's up here.
Yeah.
Are there any, because there are some concerns that I maybe didn't anticipate. So I'm going to go ahead and withdraw my motion, and I'd love to hear from
Shoba's got the floor.
yeah.
Shoba?
I hope I'm capturing the concern because I had a question mark after I seconded too, so apologies. Maybe I'm capturing the question mark. So I think the confusion in my mind is that we are talking about sort of two separate stages. We are talking about who even gets entry into the door versus what the process looks like, right? So like once you're at resentencing, that there might be a variety of factors. So if I'm saying that right, I think this principle really probably is supposed to just capture that first entry to the door. In other words, that totally understanding what Lisa was saying earlier, that language is likely unnecessary because we're going to be talking about other factors when we talk about actually what resentencing is. But I don't want to, I see Rep. Cassidy's hand up, and I don't want to assume that that's the question we have.
Kelly?
Sure. I mean, fundamentally, this begins from the place of recognizing how many different kinds of people are impacted by the thing that y'all are probably sick of hearing me talk about, the Tuesday guy and the Wednesday guy, right? And it's not limited to crimes with really long sentences. Someone who gets sentenced to 10 years when on Wednesday that crime carries a sentence of 5 years is dealing with just as much injustice as someone who was sentenced to an extraordinary long sentence when we change that guideline the next day. And so I'm uncomfortable with setting up that immediate bar to entry.
Chief Davis?
Yes, ma'am. I think I've got the same concern in that it's, for me, once again, it's about inequity in sentencing, and inequity doesn't have to necessarily be a 20-year minimum. If there's some inequity that's found, it could be a lesser sentence. So that's for me, that's just my perspective. So that was my
Okay.
perspective.
Joby?
Yeah, I mean, I will say this, I 100% agree. I want fewer barriers. I think the reason two reasons why I support this, although if there were a motion to support fewer barriers, I would vote for that too, is that one, I think most of the sentences that carry lighter term of years are not subject to the more aggressive version of truth in sentencing, right? So there are other avenues for release and other remedies for people who don't have this category of long sentences. So when we started the process, we had a presentation from SPAC about the numbers and why is it that there's so much movement and as Bob Berlin rightly noted, the prison population is down dramatically, largely because of the remedies that were opened up and loosened up and made available to people who have, the less serious offense classes. So what's left are the people who are ruled out completely of truth in sentencing, the 100%ers, the 85%ers. That's where I think the remedy is most needed. So the other reason is just, again, my sense that when we go into things like this and we're looking at inequity, I agree with you. I would do this. I'm on your side. I would do this for every single person. And if we can do that, let's do it. I'll vote on that motion. But my fear is that the concerns that we're going to hear, I think later on in the conversation about, overload on the court and the cost, there's a million different kind of things that can come up, are, mitigated somewhat by having some definition to this problem, where I would argue the need and the inequity has historically been the greatest. These are the people who have been left out of every other reform. That said, if we can get the votes to pursue something with a lower entry bar, I'm on board.
Scott?
I will, I also am 100% in favor of to the comments that Representative Cassidy has raised. And I would suggest one possible alternative could be, and I don't have language in front of me, and Representative Cassidy has got better drafters than I do, that we could think about this Tuesday, Wednesday situation within these criteria. And that we have the set criteria that we have sort of identified here, and then we just create the person is serving, what would it be? The person is serving a sentence for which the General Assembly, like, there has been a change in the law. Something has happened, a post-fact thing has happened that no longer carries with, like, that there has been a ameliorative action taken by the General Assembly. And so that would give that person eligibility to petition for resentencing. So we are dealing with the long term, the people serving long sentences, which is the core problem that SPAC's identified. And an alternative would be those for whom serving a sentence that there has been a subsequent change in the law that makes that a sentence that is no longer sort of within the range.
But
I think I would probably be comfortable with that.
I'm
What's
sorry.
your old bill number? I could pull up the language.
I'm not sure if we ever had that spelled out in legislation, but I can dig in and find it if we did.
Would the retroactivity application resolve the Tuesday, Wednesday situation?
No.
No?
Not with this limitation. Not if it's paired with this limitation. This limitation is a limitation. I also don't understand why we're negotiating against ourselves here.
Okay.
I think one thing I'll remind members of is we did talk about having a mechanism whereby petitions could be screened, and they can be screened if there are criteria that have to be met to be eligible to file. Mm-hmm. So I think that's one reason that we had this original discussion and this original thought. But if I understand Scott and Kelly correctly, and Abigail, why don't you go ahead and type this so we can just see it, and then if I'm wrong, we'll all be seeing it.
There are a couple of people in the queue.
Wait, there's Abigail. Can you see the chat? Scott just put
Judge Ingram and then Ari.
So I, like everyone else, do agree that there are probably some people who receive sentences that they shouldn't have received that are much less than 20 years. But I think early on, we had a discussion, actually at the April 29th meeting, according to my notes, where in discussing the principles and then discussing what our recommendations would be, we kind of reached a semi-consensus that we were talking about at least 20 years with, and they've served 10 years, because we were talking specifically, as stated before by Ms. Cates, about those people who were serving that extended period of time. And the thought at that meeting was that others would have the opportunity, other opportunities that may result in them being able to reduce their sentences that wasn't available to long-term people who were in prison. And so then I don't think we ever even broached the subject of that Tuesday, Wednesday situation, or people with less sentences, because that was not the original focus. And so I think it's two different things that we started out talking about, and now we're at a point where we're trying to include them all, and either we're going to include them together or separately.
Ari?
Thank you. I just had a quick question because I think I got lost a bit earlier. In terms of the procedure, so did we stop Joby's motion and vote?
She withdrew it.
Okay, so it doesn't just die. Okay, so
it.
it doesn't just die. You've withdrawn it completely, and then now, whenever this is settled, someone else will make a motion anew, and we will vote on that again.
Yeah.
Correct.
Okay, thank you.
And it appears that there is a modified criteria that's on the screen now.
We haven't dealt with one.
Any more questions?
Just to be clear, Kathy?
Just to be clear, Kathy, would you read what's on the screen?
And could we make one quick modification to what's on the screen if you take a look in the chat?
Okay, on the screen, I think we need to, Abigail, delete the maybe 2 before minimum, because we now have 3. All right, so petitioners must meet minimum criteria to be eligible for sentence modification. 1, the petitioner must be serving an aggregate sentence of at least 20 years, and the petitioner must have served at least 10 years of their sentence, or the petitioner is serving a sentence for any criminal offense under the Criminal Code of 1961 or the Criminal Code of 2012, or a similar local ordinance for which the statutory penalty has been subsequently reduced or altered. What do we mean by or altered?
Gotta ask LRB.
Okay. Shobha, do you have an answer to that question?
Not exactly. I was actually going to kind of put Representative Cassidy on the spot. I have a vague memory that when something like this was out there before, that I feel like you may have had a hand in, that there was something about class of offense being changed. I don't know if that's something that's to save for the LRB people down the line, but I just wanted to flag it. Like if the class of the penalty or offense or something was there, but I don't know if you.
I don't recall that being part of it. I think we only ever talked about sentence,
okay.
But yeah, that's definitely in the wheelhouse of the basement full of drafters.
Maybe I saw draft 15 of 25. Who knows?
It's possible.
Got it.
Thank you.
Kelly, based on your comments earlier, I just want to ask a question that is around the 20 years. Must have an aggregate sentence of 20 years. Is that
Yeah.
something you're comfortable with?
I was not comfortable with creating a limitation that left people out. I think that 1 and 2 came from folks who are more concerned with the folks who aren't eligible, or who are outside the truth in sentencing window. And so that sort of came out of nowhere from my perspective. And I apologize if somebody referenced an earlier conversation, maybe I missed that meeting. But my biggest concern is that we make relief available to people who have experienced injustice at the hands of the system, period.
Does the third criteria address that concern?
That helps significantly. I remain in this place of being concerned about, negotiating against ourselves. And I realize, as one of the handful of legislators on this call,
right.
You don't start from where you think you're going to land. And so it is possible that 1 and 2 maybe are too specific for our process. And there could be a way of revising that in a way to give us flexibility to look at the numbers, to look at who we're dealing with, and set those numbers when we're in actual bill negotiation space.
Scott, I see your hand.
I mean, I do. I guess it is worth it's worth remembering that we are not the sausage makers. We are the task force studying this problem, and so I'm really hearing from Representative Cassidy that it doesn't necessarily behoove us. It behooves us to be sort of sticking with our core mission and our core values. And so I wonder if we could add a 4th criteria to capture what Representative Cassidy just spoke to, which will be a little loosey-goosey for the room, but like it would be another or. The petitioner makes a showing that that resentencing is warranted under the pursuant to rectify an injustice or as a matter of justice. And I'm trying to look to the purposes of the task force. Like we could grab some of that language and say that that's, so you got long-term people that are serving long-term sentences, someone who is serving something that is no longer punished in the same way, or catch-all language. In the interest of justice, the person warrants this opportunity. And again, there will be a screening mechanism. There'll be, who knows, the roadblocks thrown in that individual's ultimate way. But I think we could capture the concerns to make sure that we are not blindly recommending, ignoring someone who is every bit as meritorious but is serving a 19-year sentence.
I would also suggest maybe we just take out specific numbers and make a suggestion that the legislature contemplate a condition upon which a petitioner must be serving a certain sentence and have served at least half of that or something like that. Again, like I said, because if a bill started with this, by the time I got it out of committee, it would be 50 years and 25 years.
Okay.
The other possibility is instead of a minimum criteria to be eligible for sentence modification, that the legislature could recommend factors for judges to consider and have these factors be what the judges consider. That's another approach.
Judge Ingram?
All right, so my concern is, what are we going to recommend to the legislators that could move them towards a resentencing bill? And so if we start from that perspective and we start from our prior conversations, which really have nothing to do with how many people are sentenced unfairly, because we could go with 1 year and so everybody would be eligible, or less, even probation or even supervision, if we're being real about it. But if we're tasked with recommending something that reduces the prison population, then I think it goes back to our initial discussion, as I indicated before, is that what is the majority of the prison population that we're trying to reduce? It is never, I shouldn't say that, but unless things change, it's never going to be fair, because there's always an unfair sentence. So if we're talking about reducing the prison population, and we go back to our prior discussion, that decision was to look at the largest portion of the prison population and create a resentencing for that, because everybody has the right to an appeal, which may reduce in a reduction, or post-conviction hearing, which may result in the same thing, or this new bill that now is aimed at doing the same thing the other two did, or reducing that long-term prison population. And while we want to save everybody, I don't know that this committee can make that recommendation to them and create something that we don't already have, unless we set some minimum qualifications, even though the minimum qualifications unfortunately hurt. Because now we're back to where we were a couple months ago, is what population are we dealing with? Is it everyone, or is it the long-term prison population?
Joby?
Yeah, I actually really appreciate the reminder of legislative intent. And I think, we all represent something here. We were all invited onto this task force because we represent an interest. And I think two folks at the table here who can speak to the legislative intent of the bill that created this task force are Senator Peters and Representative Cassidy. So I think if their vision for this was not to create barriers in the report, in the recommendations, but to sort of worry about barriers and process in the legislative process, then I would support absolutely would support a broader kind of look at this, and knowing that during the legislative process, it's of course going to get hammered. And my fear will always be that as the person who represents the people in my constituency, my largest concern is for the people who have no relief now. So that's what I'll continue to fight for in my role. But I don't think having a broader set of criteria in the report is, if that's what the people who passed this legislation wanted us to look at, I think we should look at that. We should debate that, having the broader open door.
Shobha?
So in the interest of moving this along, I don't know if we'll move it along. I'm looking at number 4, that's Scott's suggestion in the chat. I think that's certainly one approach to add for a broader category that accounts for interests of justice. I do also think another approach, which I don't like as much because of its lack of specificity, but I wonder if our legislative folks on this task force might like, is something more along the lines of that the legislature, that the General Assembly will come up with that criteria, that petitioners must meet criteria as established by the General Assembly, bearing in mind, and then we can provide our thoughts. I'm not sure I love that idea. We can provide some guideposts, like bearing in mind, for instance, that, you know, the task force is concerned about X, Y, and Z in particular. Or that can be a thing that goes in the comments to a recommendation. But if we want a very broad approach, that might be another way to do it.
Should we consider Scott's number 4 suggestion? Would you
I just
want
have a question of clarification. Is that, Scott, is that in addition to 1, 2, and 3, or instead of 1, 2, and 3?
I think it's in addition. I mean, because
Okay.
I don't think like it's catch-all language, so it's
Okay.
so it's 1 and 2 are clustered together, then or 3 or 4.
Okay, got it. Thank you.
And I kind of believe that in second look, in some of the second look provisions in California, they have a similar. There's similar catch-all language that sort of like you need to be this or this, or you have taken certain steps towards rehabilitation. Like there's, like it's a bit embodied in other forms of approaches to this type of question.
I just lost sound. Thank you. Okay.
And
Okay.
since we're in recommendation land, I don't think there's any. I think we could just say that, like in number 3, you think that it could be a person serving a sentence for any criminal offense for which the statutory penalty has been subsequently reduced or altered. I don't know that we have to get that, because we're not writing a bill right now. We are just writing a recommendation.
Kelly?
I maintain that I don't think that our recommendations should have the specificity of the number of years and how much of their sentence as well. The recommendation should be telling the legislature to set a preferred number, and fraction thereof. Because I promise you that number will go up and not down. And as we've said, we're not writing a bill here. We're writing the recommendations of our task force.
So to the first criteria, instead of a number of years, and I'm just throwing this out, could it be serving a sentence under pursuant to a class 2 or greater offense, which carries 7 to 15, so that the petitioner has been convicted on as I said, any class that you choose, or greater.
So I'm going to go back to the legislative process.
Okay.
You pick a number, it's going to move.
Well,
So
What
if we
about
say class 2 or higher, we're going to end up at class X, right? I think that we're trying to draft a bill when what we need to be doing is trying to draft recommendations that guide the thought process of the legislators who are going to carry this.
Okay.
And those are very different things. And I anticipate that many of the people on this call are going to participate in the drafting of the bill. There will be that opportunity, but this is drafting the recommendations of our task force.
Okay. Okay.
To pick
What
up
if
on
you-
one of
What if you just got rid of 1 and 2? Would they not be encompassed in number 4? That the person could make a showing that they've served X number of years of a X number of years sentence, and it no longer advances the interest of justice because.
Yeah.
I don't think you need to add that, Abigail.
So for the purposes of the recommendation, would it be, I'm making this up, obviously, half of a lengthy sentence?
I think I'm looking at the
And
chat.
the ors and the ors.
I think that Kathy's suggestion that 1 and 2 encompass what could lead to legislative language that looks like the old 1 and 2. That 1 and 2 as amended here.
And I think we get rid of.
It enables the legislature to add those guardrails.
And we get rid of petitioners must meet minimum criteria and substitute what Scott put in the chat, which is the General Assembly shall establish eligibility criteria,
Okay.
a sentence modification.
It's possible that's all we need to say.
Yeah. And then maybe put in the always beloved, including but not limited to 1 and 2. Okay, questions, comments, changes?
Okay, so the recommendation reads as follows. Petitioners must meet two criteria to be eligible for sentence modification. 1, the petitioner.
No, that's the old one, Mark.
Kathy, can you read what you have on your screen?
Yeah.
Okay.
The General Assembly should establish eligibility criteria for sentence modification, including but not limited to 1,
Okay.
the petitioner is serving a sentence for any criminal offense. Can we get rid of under the criminal codes for which the statutory penalty has been subsequently reduced or altered? Or the petitioner makes a showing their sentence no longer advances the interest of justice or the promotion of public safety. That gives pretty broad field for the legislative process.
Is there a motion for that?
So moved.
Second. Someone should say.
Who was the second? I heard a second, but it was breaking up.
No, that's my question. Is there a second?
Oh, sorry.
Well, I don't know which one of us was put down as having moved, so.
I
who
think
moved?
you, Kelly.
Okay, because there were two people who said so moved, so I don't know who the other person was.
That was me, and I'll second.
Thank you.
It's moved in second. Ms. Saltmarsh,
All right, Chair Salone,
yay.
Cheryl Ingram,
No.
Kelly Cassidy,
Yes.
Robert Peters,
Yes.
Mitchell Davis,
Yes.
Ari Jones,
No.
Scott Main,
Yes.
Shobha Mahadev,
Yes.
Orlando Mayorga,
Yes.
Joby Cates,
Yes.
Latoya Hughes,
Abstain.
Lisa Daniels,
Yes.
Sharon Mitchell,
Yes.
Bob Berlin.
No.
All right, we have 10 yeses, 2 noes, I'm sorry, 3 noes, 1 abstention.
All right, the ayes carry. Recommendation will be submitted. There is a question about procedural recommendations, which is as follows. A petition for resentencing may be initiated by the prosecuting attorney, the Illinois Department of Corrections, a member of the judicial branch who has overseen proceedings involving the individual serving such sentence, or defense counsel. Comments regarding procedural recommendation.
Scott?
I believe we need to add that it also needs to be the, I don't know the right language, but a pro se litigant, the individual themselves serving the sentence, because.
Judge Ingram and then Bob, then Latoya.
I'm not sure what you mean by a member of the judicial branch, but I don't know that the judicial branch should step into the role of advocating for either side. And nor do I know, I don't even know how you think that would happen, really.
Mm-hmm.
It may sound nice, but I don't even understand that.
Bob?
I was going to make the point that Judge Ingram just made. I don't know how you'd have a judge being an advocate and a member of the Department of Corrections as well. I would agree. The law already is a prosecuting attorney can file a motion, and obviously defense attorney and a pro se litigant. I would agree with all that.
Latoya and then Scott?
I would agree that the Department of Corrections should not be involved in this stage of the process by filing a petition. We do not file petitions in court. We don't even represent ourselves in court. The Attorney General's office does that. So we should not be a part of this petition filing process.
Scott, I think it jumped back to you then.
I had forgotten to take my hand down.
Oh, okay.
So it sounds like we are deleting or the suggestions, right?
Department of Corrections and the court.
And then add the incarcerated individual.
This should probably say pro se.
They may not be pro se though. They may have. They may have somebody advocating for them. who was not their defense counsel.
Mhm. We ready to call for the question? Okay. Is there a motion to receive the recommendation as follows? Petition for resentencing may be initiated by the prosecuting attorney, the incarcerated individual, or defense attorney. Is there a motion?
So moved.
Second? So no second?
No second.
I'm sorry? There being no second?
Can I be heard real quick?
Sure.
So, there are instances where a court can initiate a process. And while I don't think it would be typical for a judge to initiate a process in this case, again, I worry about our principles being too specific. So I'm fine with the way it looks now, but I just really worry about excluding processes that could exist in the future. It's my position.
How would you rewrite it?
I mean, I was fine with the way it was written before, because it said it's a may, not a shall. But those entities could choose not to initiate a process if they don't want to.
Okay.
Hi, I just similarly just have a quick thought that came up during this last exchange during the voting that Sharon mentioned. I think there is an argument to be made for not seeing a judicial initiation or an IDOC initiation as advocacy. In other words, there are times and circumstances, and I think the pandemic was actually one, where there was a sort of a community and an urgent sort of need to review a lot of cases quickly and to initiate a lot of processes that aren't used to working quickly. And some entities in the process did not have the authority or the power or the discretion to even initiate a review. And so it created a bottleneck, and we could have saved some more lives. I think there were things that I know, LaToya, I know there were things the IDOC wanted to do and couldn't do while waiting. So again, not necessarily in terms of individual advocacy, in terms of, I've spoken with probably 7 or 8 retired justices who said there were cases where they were forced to give sentences, or batches of cases, types of cases where they were forced to give sentences to people that they did not think were in the interest of justice. And I could imagine an instance, and again, I don't want to put any thoughts or words in any of the honorable justices' mouths, but having had these conversations, I'm wondering, not as individual advocacy, but as a sort of a matter of a review. If somebody got to a point in their career where they felt there had been a bulk of cases of a certain type that had fit that this doesn't feel right parameter, could they say, since no one else is initiating it, could they? And I think that that's probably the spirit that we could have behind this if we agreed to it.
Robert, Shoba, then Judge Ingram.
I just want to say I do understand and get sort of it was an aha moment of what Sharon was saying about the flexibility here. And just want to sort of lift that up, that does in fact it seems like a more flexible language, the first part there, but that's it. I just want to sort of lift that up. Thank you.
Shoba.
Yeah, I'm now looking in the chat and we're seeing that Rep. Cassidy may have taken my my point. But I was going to say initiate is sort of a broad term to begin with. We don't actually know what that's going to mean. It may not mean like filing a motion, you know, depending on what happens in the future. So perhaps the end of this sentence, another way to say what I think Rep. Cassidy's getting at here is that it may be initiated by these folks or any party designated by the legislature or by the General Assembly, or however we want to word that, something to that effect.
Cheryl.
So generally, nobody tells a judge what sentence they have to give. So I'm a little lost on that. Number two, other than what's limited by statute. Number two, if there's a situation that comes up, I mean, this is a realistic side of how it goes. And a judge thinks that, you know, it enters their mind, oh, remember case A, B, C, D, what about that? I've been thinking about that case. Then they direct either the state or the defense attorney to motion the case up. The judge cannot become an advocate and should not be put in that position. And if you put it in there, then what happens is you start to get motions that say, well, judge, you could do A, B, C, D, which creates a problem. It may sound good on paper, but in reality, it creates a problem that I don't think we need to get into. We don't represent the people who appear in front of us, period. We only represent them through whatever sentence we hand down or whatever decision we hand down. That's it.
This is a tough situation for me. I think it was Ms. Cates who mentioned talking to some retired judges who felt compelled to impose sentences they did not agree with. In most instances, that's in my experience, most instances, that's avoidable. You know, sometimes it takes some creativity, but that's avoidable. But I do understand the letter of the law. I also have some reservations about appearing to be an advocate. For the greater good of the system.
Judge, there's an idea reflected in the chat that I think might be worth considering. The legislature shall recommend parties who may initiate motions, including but not limited to. It's a variation on several elements of people's comments. Might be worth thinking about that language.
Let me see.
It's date stamp 12/18.
Yeah, I can't. Um, I'm the 12. Okay, let's see here. Oh,
I can read it again. The legislature shall recommend parties who may initiate motions, including but not limited to. And then we'd have the language as originally proposed in the revised version.
well, that's fine. That's fine. That's fine.
As a procedural question, if a retired judge who's now practicing law, maybe in a defense firm,
Yes.
that person would not be precluded from initiating a motion, correct?
Right.
Okay. Just sitting judges should not be advocates. Got it. Thank you.
As Judge Ingram pointed out, sometimes you reflect upon some rulings and you can make it right.
Judge Ingram, you have your hand up again?
Yeah, that's true. I agree. And just to Ms. Saltmarsh's point, but that's not the importance of what you said is that that's not a part of the judicial branch because they're no longer judges. They're just a practicing attorney. When you put judicial branch in, you bring us in, or them, I forgot I'm retired, them in, and they shouldn't be. And so that's only my point. I mean, but as a recommendation, I can go with what it currently says, including but not limited to prosecuting attorney, incarcerated individual, or defense counsel, which doesn't specifically indicate the judiciary. As long as it doesn't specifically indicate the judiciary, I'm fine with that. Because quite often the judiciary receives, state law, promulgated by the legislators that ties our hands, which make absolutely no sense.
Excuse me, Judge. Please check that you're on mute if you're not speaking. We're getting background noise. Actually, a background conversation.
Okay.
Okay. Sorry, Judge.
Sharon, your hand's up.
Yeah, thank you. I just want to say that I think that this edit, I think is strong, and would propose that we move forward on it.
All right. Is there a motion regarding the revised recommendation, which reads as follows: the legislature shall recommend parties who may initiate, including but
We
not
need
limited.
we need a word in there.
A motion. Initiate a motion.
Or petition. All right, initiate a motion, including but not limited to the prosecuting attorney, the incarcerated individual, or defense counsel. The motion to receive.
Can we simply say who may initiate a petition for resentencing, including, instead of a motion, just to?
Yeah. Yeah. Yes.
I'm sorry, Shoba, I didn't see you right away. Shoba?
Oh, it's fine. That's literally what I was just going to say as I kind of said it in the chat. But Scott just said. Resentencing petition.
Is there a motion regarding the recommendation as it appears now?
So moved.
Second. Is there a second?
Second.
Second.
It's moved in second. Oh, I'm sorry. Ms. Saltmarsh.
Chair Salone,
Yay.
Cheryl Ingram,
Yes.
Kelly Cassidy,
Yes.
Robert Peters,
Yeah.
Mitchell Davis,
Yes.
Ari Jones,
Yes.
Scott Main,
Yes.
Showa Mahada,
Yes.
Orlando Mayorka,
Yes.
Joby Cates,
Yes.
Latoya Hughes,
Yes.
Lisa Daniels,
Yes.
Sherrod Mitchell,
Yes.
and Bob Berlin.
No.
All right, we have 1 no and 13 yeses.
Okay, the yes is carried. The recommendation will be adopted. The,
Jake. James Swansea, could you please mute your phone? Thank you.
the next recommendation reads as follows. I don't know. Where a petition for a reduction in the sentence has been denied, the petitioner may not file a successive petition until at least 3 years have elapsed after the date the petition was denied. I think we discussed this briefly anyway on a prior occasion. Comment? Any comments?
Cassidy, same,
About
second
the
verse,
years,
same as the first.
the number?
Yep.
Yes. Where petition?
May not file a successive petition until a minimum number of years have elapsed.
Right. What is that? What would that be? The minimum
Determining the number, you mean?
Yes.
I think that's another item that happens in bill negotiation. Again, I think if we lead with a bill with 3 years, because that's what we really want is 3 years, and that's what we believe in all of our hearts is the right interval, it will end up being 5 or 10.
Okay.
Because that's just the nature of negotiation. Somebody needs to get something in order to get on board.
Judge Ingram?
If these are our recommendations, if our recommendation is 3, then at some point, either we're going to leave it all up to them or we're going to make a recommendation. And I don't think we need to be afraid to make a recommendation. And I don't know if it's automatically going to be more than what's the point of us being here? I mean, we're sitting here discussing what we think it should be, and we think it should be this. It may make sense. It may start someone to say, well, okay, maybe let's get back to the 3. I don't know if I should automatically assume that it's going to be 6 because I said 3.
I'm just speaking from my experience negotiating bills for 11 years.
Then what's the point of us being here making a recommendation if it's going to go another way anyway? I mean, if we automatically have to assume it's going to go another way, then what's the point of a recommendation?
Excuse me, what? Can you repeat that one more time? I am sorry. I just need that to be broken down. Can you please repeat that one more time?
Who repeat what?
Judge Ingram, I think he was asking for your
Something
remarks.
about, I'm a little confused because I'll be honest with you that, to be very frank, I don't know what, can you repeat that statement, please, one more time for all of us?
You were going to be very frank about what?
Judge?
Okay, my point was, we're here to make recommendations. And if it is our recommendation after discussing everything with everyone here who's had come from a different background, if our recommendation is 3, I don't understand why we need to automatically not put any minimum number of years in. And I should automatically assume if I do, it's going to be more. By the same token, if I say the minimum should be 3 years, they may very well agree with us. But if we're here to discuss it and it's our recommendation is 3, if it's automatically going to be 6, then they need to just have the legislatures on this committee here. So why can't we make a recommendation?
I agree. I agree. It may occur to some of the members of the legislature that this committee is comprised of, in most instances, of people who have spent a lifetime in criminal justice and or reform. And they may be persuaded by the recommendation. I appreciate the political process as well, but I don't think we need to kick every can down the alley. We should make a recommendation.
Robert?
Yeah, so I just want to say that this is not A, kicking the can down the road. B, it is in fact to create recommendations. The only part in this negotiation that exists is about putting limits when it comes to the time. It's the idea of the fact that there's going to be another set of negotiations. We're negotiating about certain frameworks about how we hope to negotiate about something we're going to negotiate later, essentially. And so with that, we need to be somewhat broad here on the front end because we're going to have further negotiations in the future on the actual piece of legislation. So instead of creating that limit here on, like, creating very specific limitations here in this end, we will have those conversations definitely deeper later on, so that there will be periods of, I'm sure there will be periods of agreement and adversarialness that happens in the legislative process. And I think what we're trying to say is we want to be able to actually have those negotiations about such specific things when it comes to time or numbers. Because if we do that here now, down the road, when we're having further negotiations, those numbers will change, but they'll most likely change in a way that does not allow for someone like, say, me, who might want to have some flexibility, would like it. We can at least have a recommendation that gives us some framework to work from, but not limit us too much. And I think that's the point there. I think that's what we're saying. So it's not to say no, there's still a recommendation and it's very important. The idea is that not to keep it so narrow that it makes it hard to have any flexibility to, you know, stretch your wings out, I think is really the point being made here.
Joby, and then Judge Ingram.
So I guess just for clarity's sake, there is a recommendation to be made, and it's interesting because I was so caught up in looking at the number of years that I didn't think about the underlying principle first. So when I look at the underlying principle here, we're deciding if we're going to recommend that a petitioner who has petitioned and been denied has to wait any period of time. And so there will be people on this task force who believe there shouldn't be a limit at all. And there are going to be people on this task force who believe there should be a lot of limits on when the person or how the person can file a subsequent petition after it's been denied. So, I mean, perhaps the just procedurally to get us moving, we could take a vote on the proposal as it's restated and see where we're at on that. Because you know, again, that is a thing that needs to be, that we'd like to decide on as a group. Then getting into the detail is a second kind of issue, either for now or later, depending on what the group wants to do.
Judge? Cheryl?
I think the 3 years came from a prior discussion with the group. And so, as I stated before, I just don't think we should be limited in what our recommendations are. If you take, you have advocates for the victims or survivors of, who are here. You have the legal, both state and defense and judges. You have people who've been working in the fields, toiling for this for years and years. If we all come together and we come to an agreement of a number, we should be able to make that recommendation. If we all come together and we agree that there should be no number, that should be a recommendation. But whether we include a number or not should not, and we're tasked to making recommendations, should not depend on what somebody's going to do later, because our job is to make whatever we collectively feel is the recommendation.
I see both sides. I see both sides.
Okay, let's vote on the amended recommendation, which reads as follows.
Chair Salone, there's a suggestion in the chat for a different approach. We're going to try and fit it on the screen.
Okay.
I'll speak to it real quick while that's happening. And if it's my suggestion, was it another suggestion, Kathy?
Shoba added.
And it's really just a statement to, again, thinking of who we are, what we're doing, and again, in the spirit of a recommendation, writing it in the affirmative and not in the negative. That what we are affirming, what we are stating, I believe in agreement upon, is that that there should be opportunities to file again. And and I think it's also interesting to remember too, because in the previous recommendation we decided it's not just the impacted incarcerated individual who might be seeking this, and so we should be mindful of that when we are sort of putting up barriers, because it's not necessarily just one person that is seeking this, and so I think it's good to think affirmatively that there is that a person may file a successive petition, and then we can at a time designated by the General Assembly.
Okay.
I just have a point of clarification, maybe to Scott, because I'm not sure what's on the screen is reflecting what your original suggestion was. So I just want to clarify what we're thinking about.
The original is in the shaded box.
No, not that. Sorry, what his? sorry,
Oh,
Judge.
Scott?
Yes, his original in the chat. We're looking at, I know, 3 different versions at the same time.
Is it the one in the middle? The second?
Yes. So I was just trying to track language between the two.
Okay, so let me read what should be in there. Abigail, here you go. Where a petition for a reduction in a sentence has been denied, the petitioner shall be permitted to file a successive petition for resentencing.
Within a time period to be designated.
Yeah, let her type.
Okay.
Now I think you have captured both. So the third option now reads, where a petition for a reduction in a sentence has been denied, the petitioner shall be permitted to file a successive petition for resentencing within a time period to be designated by the General Assembly. That is one option. Our first revision was where a petition for a reduction in a sentence has been denied, the petitioner may not file a successive petition until a minimum number of years have elapsed after the date the petition was denied. We'd have to gussy that up a bit. And the original referenced the successive petition filed until, may not be filed until at least 3 years have elapsed after the date of denial. So those are our 3 options.
So I know that, or I believe Judge Ingram's position is that she would support the recommendation in the shaded area. Is that correct, Judge Ingram?
Yes.
Okay. And the most recent recommendation is number 2. Which is really an attempt to, as Scott pointed out, not write in the negative, but it's a variation of the 3rd recommendation. Shall we vote on the 2nd recommendation, which reads as follows: where a petition for a reduction in a sentence has been denied, the petitioner shall be permitted to file a successive petition for resentencing within a time period to be designated by the General Assembly. Is there a motion concerning that recommendation?
Which piece are we asking for a motion on?
The second, I guess Scott's proposed recommendation.
Sure, so moved.
The highlighted one.
Yes.
I'll second that.
It's been moved in second.
Okay.
Ms. Saltmarsh?
Chair Salone,
Nay.
Cheryl Ingram,
No.
Kelly Cassidy,
Yes.
Robert Peters,
Yes.
Mitchell Davis,
Yes.
Ari Jones,
No.
Scott Main,
Yes.
Shobha Mahadev,
Yes.
Orlando Mayorga,
Yes.
Joby Cates,
Yes.
Latoya Hughes. Did we lose Latoya?
Yes, thank you.
Okay. Lisa Daniels,
No.
Sharon Mitchell,
Yes.
Bob Berlin.
No.
All right.
Did we call the chief?
Yeah.
Okay.
He had a hard stop at 1 o'clock.
We
So
have 9
He voted
yeses.
though.
He was stepping away.
No, he voted. He
He
voted.
voted.
Okay. I just didn't hear. Okay.
We have 4 noes and 9 yeses.
The yeas carry, the recommendation will be received.
Chairman Sloan, we need to go directly to public comment. If there
Okay.
is anyone who wishes to make comments.
I'm sorry, Kathy, are you sure we have 4 no's and not 5?
Let's see. 1, 2, 3, 4. Oh, you're right. I'm sorry. There were 5 no's. Thank you, Ari.
Voter
Let me recount
suppression.
my yes, it doesn't change the outcome, but yes, there were 5 no's. Sorry about that, folks. So now we have public comment. And in keeping with past tradition, please limit your comments to 3 minutes and to the subject matter covered in this meeting. If you are a member of the public and you would like to speak, please put your name in the chat, or because I don't think you can raise your hand if you're on the phone. Do we have any members of the public even on the call? I don't know. Well, Mr. Chairman, it appears that we have no public comment today.
Okay, all right. So we will have our closing reflections.
I think.
Yep,
No?
here we go. Sorry about that. Susan, do you want to mute? So it's been a long meeting and people may not be willing to stick around for closing comments, but do people want to share any reflections on either something that really struck them, something you're excited about? Or after 4 hours, you're just ready to go? Judge, I think we probably would want to entertain a motion to adjourn.
Okay.
Whoops,
Is there a
actually,
second?
Robert's hand is raised. Robert Peters.
I was just gonna say to anybody out there, they should just not start smoking because then you have to quit smoking. And I'm ornery after 6 days of no nicotine in the system. So I recommend anybody out there, don't start smoking. So.
Well, congratulations. Keep fighting a good fight. Is there a motion to adjourn?
So moved.
Second. All right, the meeting's adjourned at 12:50. Thank you all.
Thank you all.